Everyone here and at home, welcome to the Tuesday, December 15th meeting of the Morro Bay Planning Commission. Let the record reflect that all members are present and the meeting is called to order. And if you would all please start the meeting by joining us in a moment of silence. Okay, and if you'll rise and join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Thank you very much. This is a time that we have set aside for announcements from the commissioners. Are there any announcements to be made this evening? No? Richard, you're letting us down. Okay. Seeing none, then we will move on to more important business, which is our public comment period. This is a time that's set aside for members of the public who would like to speak to the commission on items which are not on tonight's agenda. So if there are any persons here who'd like to do that, please step forward, give us your name, and we'd love to hear from you. Well, we have no takers, so we will continue on down our list to the consent calendar. And the consent calendar this evening consists of our current advanced planning processing list, resolution 44-15, amended from our last meeting, and approval of the minutes from the Planning Commission meeting of October 20th and November 3rd. Are there any items that anyone would like to pull out of that, or any discussion on those items?
Chairperson Taff, I have a question.
Sure.
I would like to ask Scott, and on page 3, number 10, the Sonic Restaurant, can you give me a little bit of an update on that? This seems to be, not much has gone on since 9/30/2013.
Where we're at right now is we're in the process of putting together the environmental document. We've had some back and forth with the applicants over whether we were going to require additional information related to traffic, because we've been actively looking at a roundabout in the adjacent location. And so we've been working through that with Caltrans and SlowCog, and some of the questions came up during the review process as to whether some additional information would be needed in the traffic study. We've since worked those out, and we're moving forward now with the preparation of the environmental document.
Thank you.
Okay.
Scott, on a follow-up on that, 1840 Main Street is the location where the Shell station MTBE was found. Evidence has been shown that aquifer boundary right at that place has been breached, and sewage is entering our Morro Basin aquifer in that location. Is that going to be addressed in the environmental document? Because that information is public record and has been, and the presentation was made at the regional board a couple years ago.
Off the top of my head, I don't know the answer to the question.
I think
I mean we're aware of it, and
maybe that's
we do have documentation, in the record that speaks to it. I just can't, off the top of my head, remember what the status of it was. I don't recall.
I'll leave it. I'll talk to Rob Levick about that.
Okay.
Probably he'll be more.
Any other comments, questions? Okay. Do we have a motion to approve the consent calendar then?
Move to approve.
Second?
I'll second.
Very good. So we have a motion, a second. Any discussion on the motion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Carries 5-0. And we have an unusual item on the agenda this evening, which is new business.
This evening we have a presentation from our Assistant City Attorney, Christy Lopez, sitting at the end of the table over here. She's going to provide a presentation related to telecommunication laws. Thought it was pertinent given our recent, our last meeting, and then we have additional wireless facilities on this evening's meeting. And we've had some conversations back and forth with the City Attorney's office, and we thought it prudent to bring Christy here to give you a presentation on that. I think with that, I will turn it over to Christy.
Thank you very much.
Awesome. Good evening. Thank you very much. Like he said, my name is Christy Marie Lopez. I'm with the law firm of Alshar and Winder, the city attorney's office. I've been with Alshar and Winder for 11 years in October. Back before I started with Alshar and Winder, I went to law school in Washington, D.C. and studied telecommunications law in law school and actually specialized in communications law, interning for the Federal Communications Commission as well as CTIA, which is the wireless industry lobbying group in D.C. So my experience with wireless goes pretty far back. Since working with the firm in the last 11 years, I advise our clients on wireless telecommunications matters, as well as other communications technology issues like our PEG channels and what have you, as well as a lot of fiber that's going under our streets. That's a real popular one right now. So I wanted to go over with you, I wanted to take this opportunity because I saw you have a lot of pending wireless applications. So I wanted to take this opportunity and try to give you impression of federal and state wireless law. And when I say impression, I mean that because this is a very technical, a very nuanced area of law. Especially in light of recent federal and state legislation, it's often the case that many applications are difficult to review without the assistance of an expert. And with the proliferation of wireless technology being what it is and deployment occurring so quickly, and you'll see there's shot clocks that are in place. I think it's important to make sure staff, the Planning Commission, everybody's on the same page about what the legal parameters are that we're working in. Since the federal framework does overlay the state framework, you do have to look at both of them simultaneously, and where those projects go also impact the city's authority as it relates to the proposed installations, and we'll see that as we get in a little further. I'm going to go ahead. I did do a quick PowerPoint, but I'm hoping you guys can stop me with as many questions as you have. That way we can we can learn the most about how these laws work in application. So first, I just did a short introduction. We're going to go over some of what the technology is, sort of how the city plays different roles when it comes to different proposals, and Federal Telecommunications Act. Like I said, there's a federal framework. Some of the three main ideas we'll get from that act is where local authority is preempted, meaning we don't have a right to deny based on certain reasons because the federal government told us we couldn't. The significant gap analysis, which is federal law, it tells us sometimes when we may deny. And then again, other standards for denial. Right-of-way management and the California Public Utilities Code, because installations in the public right-of-way have a different standard than those installations that are on private property, even if it's city-owned private property. So this gives you an idea of some of the technology that we see, with the one to the farthest left being the one most out of date, as you can tell, because there's no stealthing, the antennas are far from the pole, and it's more of your traditional 9-panel antenna array. The one in the middle, as you can see, it's a little more streamlined. And then, of course, the one on the far right is, it's supposed to be a stealth palm tree, but you can see it's not so stealth. Probably my least favorite of stealthing mechanisms is the faux palm. And as you may know, there's a variety of different types of stealthing mechanisms. There's faux trees. The broadleaf tree is one of my favorites, clock towers, water towers, and what have you. This is a The distributed antenna system is a small antenna. As you can see, there's the metered box that's on a pole, and you can see the arm that reaches off just above that metered box, and then a small antenna. That's what you're seeing above that arm. That's probably about 11 inches tall. DAS equipment can sometimes be seen as a little more residential friendly because it is much smaller. And it can go on existing utility poles or existing infrastructure. You would, however, need more because they don't have as far of a reach. It's a lower powered antenna, and you would need. You just need more to cover the area. And it's also good to get in communities that have sort of nooks and crannies based on the terrain. It's a good way to get into sort of nooks and crannies. If you have high areas and low areas, they can daisy chain these in the community so that you can get around certain places that would have a gap in coverage. Whereas macro antennas like the ones we just saw can't really get into the nooks and crannies necessarily. This is becoming a new type of antenna. It's called a small cell antenna. As you can see, they can engineer them pretty small. They're not commercially used right now by our carriers, but they're definitely starting to become more used within office buildings to have greater access. It gives you more capacity on the existing wireless infrastructure. And unlike the DAS equipment where we just talked about, the ones on the utility poles, it doesn't require a series of antennas to talk to each other. So that's some of the new technology that we have, just to give you an idea. And it is all moving so quickly. I mean, as fast as I can tell you about this, it's going to change tomorrow. Light standards and having canisters on top of the light standards to put antennas in, or side-mounted panels. There's all sorts of new and inventive ways that they've figured out how to install these or engineer these, and I'm sure it will move just as quickly as we go forward with technology being what it is. So the city's role. Now this becomes important because the role the city's playing impacts the authority that the city has over conditioning and approval of a proposed wireless installation. So there's 3 different roles the city can play when it has a proposed wireless installation. One is through its zoning authority. I understand that you guys don't have a wireless ordinance per se with detailed restrictions or regulations for the location, height, appearance, and what have you of your wireless installations, whether it's in the right-of-way or whether it's on private property. But certainly your zoning authority, particularly for private property, is one that reaches a little bit further than the one on the right-of-way management side. So to the extent you don't have a wireless ordinance, that's something we certainly recommend that you have, because that increases the city's authority to take action. And we'll get further into that. We will see a little bit later as we go into the case law and how the courts actually rely on the city's own municipal code to determine what the city was authorized to do. Now, right-of-way management is probably the most limited authority that you have. The state of California is unique in that the California Public Utilities Commission has limited our authority in that area. And we'll get into that a lot further. Of course, the most broad authority you have to regulate an installation is when it's your own property and you're the landlord and you're leasing out or licensing out your city park, your city public works department for an installation on your own property. Of course, you've got contractual rights that you can use to condition the proposed installation to be consistent and compatible with the surrounding neighborhood. Okay, so let's start on the federal side, since this is a very important area. It's sort of where you start in all wireless installations. What the Federal Telecommunications Act is trying to do and continues to do, it's trying to accelerate the rapid deployment of telecommunications. And this goes back to even in the wireline days when they were trying to reach rural areas and trying to get telephones into every home across the United States. It's now, of course, been expanded to wireless technology, broadband technology. Presidential campaigns have campaigned on the deployment and the rapid deployment of high-speed broadband. And that's where the wireless issues come in, because now we use our wireless phones for data and what have you. So as we use our phones for more things like 4G technology, the more antennas are necessary because there's more data that's going over those antennas. They need more capacity. And if they're using up all the capacity on one tower, then they need to build another tower so that they can bounce off more data off of that tower. So the main policy is the rapid deployment of this technology. And for the purposes of wireless, that means more antennas. Now, the Telecommunications Act it says that what we can't do is we can't prohibit a wireless carrier from providing service. And this is going to go into the significant gap analysis that I alluded to earlier, and we're going to go into a little bit further. But if the city takes an action which prohibits a carrier from providing service to its customers, then we're in violation of federal law. Okay, and how that gets interpreted, of course, is by case law, because what prohibits means the courts actually used to say that if it even had the chance, if it could prohibit, your ordinance could prohibit cell phone carriers from providing service, that was sufficient. Now you need an actual prohibition. And they have some burdens to meet themselves under the significant gap analysis, but we'll get there. I just want to give you a sense of the Telecom Act. Now, this is where it comes back to the local government. It says in the Telecom Act, under 332, that this act was not intended to affect the authority of a state or local government regarding the placement, construction, and modification of personal wireless facilities. This law has been substantially interpreted over the years to figure out what it is that the local entities have when it comes to this local authority. There's been a lot of case law since the passage of this section of the Act, and we do have a little bit of a better idea now thanks to some federal case law. But we'll get into that a little bit in more detail. And this is the final one, that we cannot unreasonably discriminate amongst functionally equivalent services. Now this, again, unreasonable discrimination. We can't discriminate against people who are similarly situated, right? And we can't unreasonably discriminate against them. So the courts look at this and they say, Is the carrier providing the same service? Was the installation similar to the installation before? So the courts have specifically said that, we're not going to compare a 60-foot cell tower in a commercial zone to a 60-foot cell tower in a residential zone. You're not similarly situated. We're going to compare a stealth cell tower in a residential zone with a stealth cell tower in a residential zone. Obviously, if they substantially differentiate, that one is much higher than the other, the courts would not likely say they were similarly situated. What's also key about this language on discrimination is that you can discriminate amongst the cell towers as long as you do it reasonably, right? And the courts say you have to support why you think it's appropriate for you to discriminate from one to the other. You have to have a basis for why you're treating them differently. It's only when you're unreasonable that you violate the law. And reasonableness goes to the reasonable person standard, which we all learned about in law school, like day one, and nobody can ever really figure out by the time you're done. It just, every community has its own standards for what reasonable is, right? But discrimination is almost always the arguments made by the carriers, because they say, well, you let this carrier go in here and, half a mile away, we're proposing the same thing, but we were denied. So you're discriminating against us in violation of the Federal Telecom Act. It's very fact specific, as is most issues when it comes to wireless telecommunications. Okay, so as I alluded to, when we talked about the federal law, we can't prohibit wireless carriers, right? And I was saying before, it could just be some imaginable, prohibition, and the court said, okay, well, then your ordinance was in violation. Now it has to have the actual effect of banning wireless services. They have to prove it, basically, that they're somehow prohibited from providing a service to their customers. And the way that the courts have looked at this is they say if the carrier has a significant gap in service, then and we don't allow them to install a tower to fill that gap, then we've effectively prohibited them from providing service. Right? Now, what does a significant gap mean? That, again, is a very expert, it's something you typically would hire an RF engineer, an expert, who would analyze what a significant gap is. The courts have said, a small gap isn't significant, but I think, again, this is very fact-specific. It's going to depend on the number of customers and what have you, before an RF engineer would be able to determine whether, in fact, a significant gap actually exists. Now, it used to be that a significant gap in service meant I could not get any service on my phone, right? I would try to dial out and I could not get service, or somebody would try to call me and the call would not go through. That's what's called a horizontal significant gap, right? There is some lower level case law that is starting to suggest that capacity, which is a death level, right? A lack of capacity could result in a significant gap. So the lack of capacity means you don't get your data, right? You can't Facebook, or you can't search, there's all sorts of other data apps that we all use on our phones. It can also mean that your phone isn't working in vehicle or in building. That's different, than what was the traditional significant gap analysis. So now we do see this lack of capacity issue coming up more and more, especially because, like I said, we've got presidential mandates about, broadband deployment being a really big issue, and without the data accessing on our phones, then we don't really have broadband. It's just, it's limited to just telecommunications or just voice. Okay, so now the significant gap analysis, this has been looked at throughout a number of different issues. Like I said, gap versus capacity, that's at the bottom. That's what I just discussed. That's becoming more and more of an issue. And the providers, typically under a wireless ordinance, are required to provide propagation maps, and they show signal strength, right? And they can show a weakness in a certain area to say, look, this is the gap that we're trying to cover. And when we put the tower right here, see how red goes to green, and now we've covered, our gap. And that's the first burden. But the significant gap analysis does not stop there. The tower installation, or the carrier, must also establish that the proposed installation is the least intrusive means possible. So it should be stealth. It's got to have some sort of concealment factors. It's at the lowest possible height that it needs. Often height is a big issue, as you might imagine, because antennas often need to be higher up, and a lot of infrastructure isn't that high, or as high as the antennas need to be. So that, again, least intrusive means is very fact-specific, very community-specific. So the one thing we do know when it comes to denying applications or proposed installations, the case law has made it clear aesthetics can be one, right? We can deny something that is not aesthetically compatible, but keep in mind the case law that has said aesthetics is acceptable in saying things like, it wasn't, if the Planning Commission, for example, denied it because it wasn't compatible with surrounding infrastructure, their code most likely said that the tower had to be compatible with existing infrastructure, So they're basing the denial based on issues that are present, are findings that the code says that they need to find to approve or deny. And then they say, oh, well, we can't make that finding because it's not stealth or not stealth sufficiently. That goes to the least intrusive means. That analysis is very simple, right? If it's aesthetically compatible, then it's most likely the least intrusive means. So a lot of times those kind of run hand in hand. What they have made very, very clear is that denials cannot be based on RF emissions. The FCC has made it really clear that unless the RF emissions exceed the FCC standards, then we cannot deny a proposed installation based on RF emissions. That if the carrier shows they're compliant with those FCC standards, then a denial cannot be based on those issues. And again, that kind of issue can be evaluated by an RF engineer and expert in the field, which I know a number of cities will rely on if you've got controversial sites. Now, should you try to deny a wireless facility, the case law and the code, the federal code and the federal case law make clear that there's one way to do it, and that is to use substantial evidence, and that is to do it in writing, right? So in the state of California, it's not a real big issue for our planning commissions because we're required to reduce our findings in writing to a resolution. You know, that's not true for all states. So that's why federal law says it has to be in writing, because some planning commissions or zoning boards would deny it just based on oral testimony, and there wouldn't be real clear findings. And so that's why federal law now requires everybody to put their findings in writing. So substantial evidence, what is that? It says, this doesn't really help, less than a preponderance, but more than a scintilla of evidence. That's too legal to be helpful, right? It basically means that relevant evidence, it needs to be relevant evidence as a reasonable mind might accept as adequate. So again, we go back to this reasonableness standard, right? You know, what did the Planning Commission, did the Zoning Board, you know, reasonably rely on the concerns raised by, you know, the community if to the extent that there were aesthetic concerns? Did those concerns make sense? You know, so reasonableness, as you can see, continues to be kind of a common theme here. And again, I think a lot of that has to do with, I know I sound like a broken record, is these are really fact specific. If any case law you would read on this will come down to the very testimony at the Planning Commission, to the very detailed facts of what was submitted to the Planning Commission for review, and the very detailed findings that the Planning Commission wrote up when it, you know, decided to deny a wireless facility. And if this all wasn't enough fun to begin with, the FCC has made it even more fun by instituting shot clocks, 3 of which, meaning the city has to approve or deny proposed wireless installations within a certain amount of time. I would go into this into more detail, but I actually give full presentations on Section 6409 and AB 57, which are 2 shot clocks. There's actually a 3rd shot clock. And those presentations by themselves take an hour and a half because these shot clocks are ridiculously complicated at points. So I don't want to spend a lot of time on that, but the city is required to approve or deny an application within a reasonable period of time. And that was under the Telecom Act. And what happened was the carriers got upset. They thought cities were taking too long to make decisions. And so they had a federal statute passed in the Middle Class Tax Relief Act, because nothing says wireless like tax relief, that required a federal shot clock, right? So then that was one of our shot clocks. They had a shot clock before that, but, it wasn't, I guess, sufficient. And then most recently, AB 57 was passed by the state legislature, which resulted in even more of a shot clock. So this becomes a very technical area of how to handle things. There's issues such as, we kind of get one bite at the apple in terms of notice of incomplete. I mean, there's all these detailed areas. But if I were to reduce it down to like the Reader's Digest version of it without getting into all the complexities, basically the city, if they get a co-location or modification which does not result in a substantial change, and a substantial change is actually substantial in my opinion. I've read the FCC order, and it's, they can raise a tower up to 20 feet without resulting in a substantial change. But having said that, if let's say it's 21 feet, that would result in a substantial change. So if it's a co-location or modification not resulting in a substantial change, the city has 60 days to approve or deny. If it's a substantial change, they have 90 days to approve, and basically 150 days for all the new facilities. Now, when you calculate the shot clocks, it couldn't be more difficult. It stops and starts and stops and starts and stops and starts depending on when people submit stuff, and so it can sort of be mentally challenging sometimes to figure out when the shot clock started, when we told it, when we started it back up again. But that we just have to be cognizant that this is one of those issues. Depending under which shot clock you're under, if it expires, it could be deemed approved. The facility could be deemed approved, and then the city has to file in court in order to have the deemed approval remedy overturned. Okay, so that's federal law. Maybe I should stop for a second and see if you have any questions with regards to federal law, because I know that was a whole lot, and I'm sorry, I know I speak a little quickly, but I will try to slow down a touch.
Who'd like to? I'm sure we all have questions. Who'd like to start? Mike.
So, Ms. Lopez, if other communities have enacted regulations that you recommended that we do in your first opening statement, then it wouldn't be unreasonable to assume that communities could put restrictions on certain aspects of this in terms of things like location and distance between. That wouldn't be unreasonable, correct?
I think it's a lot cleaner under the federal case law, because the case law relies on the local ordinance to say you acted reasonably and consistent with local laws. The Federal Telecom Act specifically says that the Planning Commission's jurisdiction is they can act consistent with local laws. So if your local laws say that it is appropriate for the Planning Commission to consider X, Y, and Z, then of course it would be appropriate for the Planning Commission to consider that. Now, again, the federal law tells us what we can and can't consider, but I think under federal law, it's certainly a lot cleaner and supportable if you have an ordinance to point to say, this is what we're required to find.
But it wouldn't be unreasonable if we could say other communities in our situation have imposed regulations, then quoting what other communities have found to be appropriate. Why wouldn't that be appropriate for us during a hearing process when we have an open discussion about what the community's values are to have something that we could impose?
I totally agree that the community's values in terms of making a framework for your decision would be appropriate, but the other communities' laws aren't applicable within the jurisdictional boundaries of Morro Bay, so it's not as clean. I'm just, from a lawyer's perspective, I can win a case if I'm arguing your ordinance and your local jurisdiction. I can't argue that you have the jurisdiction under somebody else's code, for example.
But it wouldn't be unreasonable to acknowledge other people have successfully put these things forward, correct?
Yeah, absolutely not.
And then the idea of this spot coverage, who's got to prove that the denial creates a blank spot?
Like a significant gap?
Yes.
Under most wireless ordinances, propagation maps are required, so they actually establish the significant gap at the application process to show this is the red zone, and this is why we want the tower here, is to fill that red zone. So it's typically the burden falls on the applicant to show that there's a significant gap in service.
So if we would say a particular location might be denied because of community input during a public hearing that's based on distances that other communities that we feel are similar to us have found as reasonable, we might have a reasonable piece of information to discuss, and that other reasonable people have come to the conclusion that they want to put
Yeah, well, the only problem with that
restrictions
is that RF propagation maps are very technical, and the distance that an antenna can reach and the number of customers it can reach depends, one, on the type of technology. Every carrier actually uses different types of technology, so it would depend on who the carrier is, what type of technology they have, what kind of terrain you have, whether is it hilly, is there a lot of low-lying levels, as well as existing infrastructure which would interfere with the antennas talking to the phones. So it's very site-specific in that term.
Okay. I think that's it for now. Thanks.
Okay. Did you guys want to make any comment? Okay.
You had on your PowerPoint one of the things about roles of a city. Remember? Do you remember that one screen? It was called Roles of a City, and then it had number
yeah.
one, zoning authority. But you failed to put the most important one, why we're all here, and that's the public's health and safety. That's the role of a city elected, okay? Now, back in the 60s, they didn't have any cell towers and stuff, and they happen to be sometimes safe too, sometimes, But it seems to me that, we can scare what the federal government can do this and do this, but the local citizenry have a right to have a say in this. And that's why I think that it would be reasonable. Right now, we are in the midst of updating our general plan that hasn't been updated for I don't know how long. That it would be reasonable to come up with put a stop on all these cell towers right now, just to stop, and let's get some parameters and the right tools for our staff to use. Otherwise, we are spending a whole bunch of staff time on things that are it's like grabbing air. We need some parameters, and then we give it's an exercise in good governance. That's what it is. We can't just look at the federal government and they're just going to trump everybody. That's not true. California has we're actually a city that has been entrusted by the California State Lands Commission with a Tidelands grant. We hold a higher fiduciary duty as a city just because of that. So looking at it as a city as a whole, we have to look at the citizens first, and we have plenty of people that have concerns. Now, I have a friend of mine, a dear friend, that she works in a dentist office, and she has a friend. One of her patients has MS, and lived in Arroyo Grande near a bunch of power, and her health was deteriorating. She's moved to San Luis since then. Her health has improved. She asked her doctor. This has an effect on people that are sick. So we need to have these discussions in the open. And that's reasonable. That would be of reasonable mind. Just to go blindly and start approving everything, that's not of reasonable mind, in my opinion.
Yeah. And if I could comment, certainly the health and safety perspective from the Planning Commission is one of your zoning authorities. That is a part of your jurisdiction as the Planning Commission, absolutely. Now, the federal government has specifically said that we cannot deny an installation based on RF emission health and safety concerns. They straight up said we cannot do it if the carrier shows it's compliant with the FCC guidelines. We can deny a structure if there's other objective health and safety standards, such as building code concerns. Like if we haven't established it's going, for some reason that's not consistent with our building code, or seismic issues that you may have issues with. Wind load analysis is also a very important analysis. That's often done, though, at the construction phase, right? Not at the Planning Commission phase. But if we see that the installation isn't going to comply, it's somehow going to fall over and endanger the community, then those objective health and safety standards can be looked at for trying to prevent an installation from going in. And I have to agree with you that, with all of these deployments occurring so quickly, and I can see that you guys have a lot of pending wireless applications, and it's hard because I think every community is getting inundated. Unfortunately for us, the federal government has said we cannot use a moratorium to stop the approval or denial process. When they adopted those shot clocks we talked about, they said those shot clocks exist regardless of any moratorium we try to impose. So unfortunately, we can't stop like we normally would under our moratorium powers and, put together an urgency ordinance and say, look, we're going to study this, and then we're going to put together the correct codes, and we're going to move forward. Unfortunately, we can't do that under federal government. We'd still be required to approve or deny these within the time periods under the federal shot clocks. I would definitely encourage, it doesn't mean we shouldn't be working forward to getting, a good application process in place and good, like you said, good parameters for these as we go forward, and using every bit of authority we have as we analyze these applications, even without the existing ordinance. But sadly, they knew cities were going to do that, and the federal government said we couldn't. So it's unfortunate.
What I'm not saying like a moratorium. What I would like to see, what I'm talking about is giving our staff the right tools. There's other cities that have ordinances and that we can use, but we need to have, we can't be approving things with no parameters, and that's what we need. We need the right tools. So I think it's reasonable that regardless of how fast the shop clock thing is, that we bring it up to even have it go to city council, say maybe even the next election or whatever. That's moving forward. We're not saying denied. The applicants are spending a lot of money just presenting it, and they have their science. But we should hear the science from both sides of the aisle to make good governance. Just requires that.
Absolutely.
Gary?
Yeah, I have a couple questions here. If a company A has located a site in a specific location and company V goes in to put another site in close proximity or in co-locating, can we deny one company after a previous company has been approved for that same or close proximity to that site?
Yeah, that goes to this, unreasonable discrimination clause under federal government, and all of the case law on that is very fact specific. So you would have to look at the sites side by side, basically, and say, are they both stealth? Are we looking at substantially different heights? Certainly after the adoption of a code, you can also say, well, now we've got a new framework that they need to meet. So even though we approved this one previously, our new code doesn't allow us to approve this new proposed one because our standards require that, X, Y, and Z. So that's obviously a way that we can differentiate amongst the sites. But if there isn't the trigger, a substantial change in circumstance, like a new ordinance in place, then you would be looking, fact to fact on the sites. Is one closer to residential? Is one closer to commercial? It's all very site specific.
Okay. And then can we deny or a specific site based on proximity to schools or residences or hospitals or any other occupation zone? Or
sensitive uses is sort of what you're referring to.
Yes.
I can tell you that a sensitive use in and of itself is not a sufficient reason to deny. It's typically sort of a red flag that you're trying to deny it based on RF emissions, which is preempted. It doesn't mean you can't deny it on legitimate reasons, such as aesthetics or other reasons. Aesthetics is your hugest one. Least intrusive means is the reason, or you can't meet your findings in your code, which requires, that it be compatible, that it's be stealth, what have you. So you could deny it on those bases.
Okay. So if it exceeded the height limit of a zone, then it could be denied based on it exceeding the height limit.
Assuming, this is the catch-all to every ordinance, you basically write the standards as you'd like them, and then you have sort of an exception that says if the carrier can establish a significant gap in service, as allowed for under federal law, then they can get this exception, to allow them, because to write your ordinance any other way, we would violate federal law.
Okay, thank you.
As it relates to aesthetics, which can be personal to a lot of people, and depending, and it's usually not fully fleshed out in ordinances and zone. Do we have an obligation to go back to let the carrier go back and make modifications to change the aesthetics, or can we deny it based on, a vote of 5 on an aesthetic basis?
Well, yeah, no, definitely aesthetics is a reason. I mean, we still need substantial evidence to support the commission's findings that, it wasn't compatible with the community. Most of the time, though, I do find carriers are willing to work with Planning Commission and staff to find a joint resolution, where you've got something installed that you think everybody's going to be happy with. That's typically where I find it. There are certainly controversial sites. I'm not to say that every site is that way, but you're never going to get the moon if you don't ask for it, right? So if we want something to be more compatible, we don't find that the proposed installation is up to par with the city's standards, we need to go back perhaps to the drawing board and see if the carrier can find something that's a little more consistent with what the community wants to see.
Okay. Yeah, I want to go back to the concept of setting a minimum distance that towers can be within each other, because to me, I'm having a hard time finding how that is consistent with the prohibition on discrimination. In other words, let's say, just a theoretical, let's say that 15 years ago, AT&T came in and just built cell towers all over town, okay, and had great coverage. And and we said, okay, that's, they're all 1,000 feet apart. That's our standard. We're not going to allow any cell towers closer than that. And then Verizon comes in and wants to put in a cell tower. How do we not prevent? I mean, that's obviously a significant gap in their coverage. How could that prohibition or that minimum distance between towers be compatible with not discriminating against the second company that comes in?
No, I see what you're saying. Now, I like that you brought up the issue between tower distance, because I think cities often take two different approaches. One, they don't want to see cell tower farms, so they require there's a certain distance between every cell tower installation, and the other, they want to see it just dense, kind of in the commercial area, and we've got some all clustered together. Now, in the case of what you're bringing up, first we see, can they co-locate on the AT&T tower? Is that technologically feasible? Because then you don't need a new tower, and you don't have to worry about violating the code in terms of the distance from the other tower. Again, that ordinance that requires a distance between towers would have that exception clause specifically for the significant gap analysis. And they would, even if the code says that, it has to be a certain distance away, they need an exception, they still have to show it's the least intrusive means, such as going on existing infrastructure, being stealth on a rooftop, what have you.
Okay. And just to follow up on that, obviously there's a huge difference in the aesthetics between the different types of towers that you've demonstrated, going all the way down to the one that you can hold in your hand, basically. Mm-hmm. So how would one go about devising an ordinance based primarily on aesthetics that would define that minimum distance for all of these different kinds of towers? Would you have to deal with each kind of tower individually to do that?
I find that the macro sites, the large ones, are typically, they're almost always installed on private property, and the reason is they require large equipment shelters, right? So you can't, unless you're going to underground that equipment shelter, you can't install them in the right-of-way and meet ADA compliance. Some carriers will install those underground, but they've found that they're harder to maintain, and they've gotten more expensive. But there certainly were carriers a while back that were trying that. And as we get further into the right-of-way management issue, you'll see why they want to be in the right-of-way. But that's the reason why the small cells, the DAS equipment like I was showing you before, those go in the right-of-way on existing infrastructure. So those are very common in the right-of-way. The macro sites are very common on private property.
Right, but I guess to me, there's very big differences in the aesthetic impacts between the two of them. So, would a reasonable ordinance dealing with a minimum distance between them not have to deal with, are we talking at one of the big towers or one of the smaller ones? I mean, it seems to me that would be a huge shortcoming of an ordinance that just said, okay, cell towers have to be X amount apart.
I see your point. Well, the difference is that typically, well, not lots of times when city adopts a wireless ordinance, they adopt two. One is to regulate installations in the right-of-way, and one is to regulate on private property. So the one that's regulating on private property may have one distance requirement, and the one regulating in the right-of-way will have a different distance requirement. And part of that is just technological as well as aesthetics.
Okay. Any other questions? Michael?
Ms. Lopez, you talked about all of these objective criteria, but we're not an objective body. We're a subjective, intersubjective body. I mean, zoning isn't building code. Building code takes care of objective issues, exiting, structure. Zoning's community values. When the Planning Commission is totally about hearing things based on community discernment that goes well beyond anything objective. When we look at somebody proposing a distance in a side yard, it's a community value. It has nothing to do with fire codes and things like that. That's in the building code. So I guess I'm very concerned when we take a community values issue, like location of technology that's evolving. We're talking about an ordinance that was put together 20 years ago that never conceived that we would have applicants in here, as was testified last time, putting 20 cell towers in our community. We have absolutely nothing here, based on what I'm understanding, to prohibit co-locations, lateral locations, next-door locations. We have nothing to protect our schools. We have nothing to protect any special zoning interests that the community may have to preempt or make more safe what the federal government is saying to do. So what I'm very concerned about is, on one hand, you say reasonableness. You've said several times other communities that put in criteria, and you've mentioned separation. What's wrong with us asking for separation tonight as a community value without having the structure inside the zoning ordinances?
Well, I just want to distinguish between two things real quick. On the health and safety side, the federal government said the health and safety issues is one, we can't do RF emissions, and two, the health and safety standards have to be objective. That's where the objective side comes in. The subjective side, your community values, like you refer to them as, that is your aesthetic zoning authority that you have to protect your community. The least intrusive means that I keep referring to, that is the one that has a little more flexibility because it's community specific. What's appropriate here in Morro Bay isn't the same thing that's appropriate in Newport Beach, or isn't going to be the same thing that's appropriate in San Francisco. So it's site specific, fact specific, and community specific on the aesthetic, least intrusive means side. It's only the other health and safety issues that are objective.
But if other communities have distance criteria, how is that not violating health and safety from your point of view?
Well, what do you mean? Like the fact that they have to be,
so
that's
many feet
an
apart.
aesthetic. They don't want to see clustered antennas, right? So that's, like, I often write these in my ordinances, is that, like, on a right-of-way management ordinance, that they can't be any closer than 90 feet from each other. In some of our communities, because of the terrain, the macro cells don't work well. So every carrier wants a small cell antenna. And so then, they only so many can go up on existing utility poles, so then they want new poles, and we don't want our streets lined, right, with antenna after antenna every 15 feet or whatever the Public Utilities Commission says. There's distance requirements for poles, of course, by the Public Utilities Commission. We don't want that in a community necessarily, and we don't want it on our coastline, So, okay, so we're going to regulate it to say if it's in the view shed area, if it's on the coastal line, it has to meet certain standards, and they have to be 90 feet apart from each other so that we don't end up with, a whole set of just antenna after antenna.
One of our citizens sent something forward that quoted Los Angeles Unified School District has a 1,000-foot perimeter around school facilities. Do you know that to be true?
No, I don't. I don't know. I've never looked at that before.
Okay. Is it?
The school districts are usually private property, and so they have their own rules and regulations to say whether or not they can go on schools. The schools can often be designated as a sensitive use, meaning a sensitive use may trigger a public hearing, for example, as opposed to an administrative approval. And some school districts actually encourage the location of facilities because they use the revenue.
But it wouldn't be unusual for a community to want to have a sensitive site protected.
No, not at all. Yeah, that's very often a term that we define in codes.
So if it's not unreasonable to see that other people have done that, would it be unreasonable to assume that this commission might have the capacity to put protection up for what the community is bringing forward as sensitive sites?
I'm sorry, I don't think I understand.
Well, if it's not unreasonable for communities to put ordinances together that protect sensitive sites, isn't it in our discretion, if brought forward by the community, the nature of some sites thought to be sensitive, that we can't protect them through our actions here?
I think that, the way sensitive sites work under the analysis under federal law, you have to show that you had, substantial evidence to support why you came to a conclusion, whatever that conclusion is. So it's hard to talk about it in the abstract, simply because we don't want to site near a school. We'd have to be able to describe what our aesthetic basis was for not wanting it near that school, or why we felt like it wasn't the least intrusive means. For example, it could have gone further down the road, didn't have to be in front of the school to fill their gap. Or they could have used DAS equipment instead of a macro site, different types of ways to look at the way, but again, it's very application and site specific.
Thanks.
A couple things. You mentioned this emerging technology, the iPad-looking thing. Now, that, is it a safer... What is it? It's just because it's small? That's why?
Right now, those are mostly being used in buildings to increase capacity for people who are having difficulty getting coverage within buildings.
Okay.
Yeah.
All right. You also mentioned that a significant gap in service is like a lack of capacity. So
it could, we're going that way.
Yeah, going that way. It could work, right? So those kind of things could kind of like, you have a lack of capacity in a localized area, you could probably get those little iPad thing. The other thing that I'm concerned about is this significant gap is like so kind of ambiguous, because to me I could see, now we have speed of access, how fast I could get it. Is that a significant gap? And then it's it's a never-ending circle. As I go back, it's not. I think that these kind of issues, emerging issues, need as a community, needs to have that discussion and have that opportunity, okay? Because I just don't, once again, it's like we're talking about distances and this. I don't see, if you wrote an ordinance before, maybe perfect. This is what we need, okay? But we need to have that discussion where that can give them the tools to do it. So then it's efficient use of time and efficient use of funding. I don't know how else clearer to make it, because right now it's not that way.
And I have to agree with you that the significant gap test is far from easy to understand, and typically anything that is controversial and there's a discussion about whether a significant gap exists requires an RF engineer, an expert, to look at the maps. And he knows what further testing, such as drive tests and what have you. But it is a very difficult issue to try to analyze without an expert.
Ms. Lopez, I think that what you're feeling a little bit is it's not like it's individual to any of these antennas. It's just that there are so many of them coming on, and we don't have the tools in order to make a decision to slow it down and get more information and to come up with an ordinance that works for the community. And we've had one public hearing, I guess last week, where we had some community input, and we will have one tonight. But I think it's a larger issue when they're speaking to 20 to 25 new antennas going in a relatively small area. Morro Bay is not that large. I think that it's a frustration, at least I'm feeling frustrated, that I don't have the tools in order to make a good decision on what's the right thing to do. I can make a decision one by one, but it's the whole. And I think that's what I'm feeling, a frustration, is that we can't stop the process. You know, we have 3 here, we might have 5 more coming in, and have an educated discussion about it, where we can come up with an ordinance where it can be addressed. And we know we're going to need them. It's not, you know, everybody has their iPhones, their iPads, and they need the data. But what's the best way to accomplish that in Morro Bay? And I think that's, you may be sensing that, at least I wanted to tell you that I'm frustrated.
Yeah, no, and I appreciate that. Sadly, Morro Bay is not the only, community. I think every community's facing this type of issue in terms of trying to address the cumulative impacts of how this is going to affect your community. I have one client that has 40 pending wireless installations for the right-of-way. I mean, you could imagine when we got this client, I wanted to cry, because how am I going to be able to help the city, get an ordinance in place, an application process in place to deal with this before it's too late, and the small cell antennas that are going up in the right-of-way, like I said, are a little bit more residential friendly. Unfortunately, though, they often bring a lot more antennas, and that causes more concern for the community. So I know exactly where you're coming from.
Just one. Speaking of emerging technologies, there's several companies now that are working on a censored and basically smart lighting, where they're embedding cell sites and sensors and Wi-Fi all in Cobra heads for lights and LED lights and stuff. So if we create a ordinance that requires a 90-foot gap per cell site, how is that going to incorporate the new emerging technologies that may actually be safer than spot antennas?
Yeah, the canisters on top of the light structures, we call them canisters because they kind of look like a can sitting on top of the light. Very popular. I think they're probably one of the better stealth way to do it, because the infrastructure exists, right? No new poles. We don't actually have to see the antennas, and the canister matches the color of your light standard. Typically, your light standards won't be any closer than 90 feet. So that's how we accomplish that. And if it's the case that we have light standards that are closer, then we look at that before we adopt the ordinance. Or, we try to get some caveat for existing infrastructure. The last thing we want, typically with right-of-way ordinances, is new poles in our right-of-way.
So, as you, and I'm sorry, I apologize, because I realize we're getting a little off of the question of federal, specifically federal regulation. But I think one of the things that we're beginning to struggle with here, is the issue of findings and appropriately specific findings. And so let me just ask you, is the generation of community anxiety a valid criteria for denial?
We have to go to substantial evidence, right? So it would be what your anxiety is based on. So if your anxiety is based on RF emissions, then no, that's not an appropriate basis to deny the application. If your anxiety is based on the fact that the proposal is not compatible with your community from an aesthetic perspective, that you feel like it can be designed better to be more compatible with your existing infrastructure, your existing residences, your existing commercial buildings, wherever the location may be, then that would be different.
And yet, anxiety is not environmental. It's not an environmental factor. It's what 704 prohibits is denial on environmental factors, right? But
on
community
pardon? On RF emissions specifically.
Well, yeah. Okay. So, community anxiety is not RF emissions. It's a phenomena which may be related to that, but it's not. We're not. It. And I think the evidence for that is that you can talk about RF levels until you're blue in the face, and you don't change the anxiety level very much.
I can totally appreciate, what you're saying. from a legal standpoint, if you were to get sued, because I, as your lawyer, think of only things, I always
course.
have to think that way, right?
That's why you make the big bucks.
I would write the resolution of denial as in a manner in which I could legally support. If you're sued, the hope would be 95% of the chance, as we wrote that denial, that it is legally supportable. If we were to just use the term anxiety of the community or community anxiety, I could tell you I would have a very difficult time in a court of law trying to support that, because they would say there's not, you didn't define anxiety. What was the substantial evidence to support the anxiety, which, therefore defines the anxiety?
Okay, thank you.
Yep. Shall we go back to the right-of-way? Or?
I think, yeah.
Well, you guys are certainly making me work for my money tonight. This is fun. Okay, so when it comes to right-of-way management, it's the area of law where we have the least amount of zoning or least amount of local authority. Like I said, the state of California is relatively unique in that they adopted this Public Utilities Code, Section 7901, which, much like the Federal Telecom Act, its intent was to expedite the deployment of wireline telecommunications, right? And so they said no city could charge rent. They could not require telecommunications companies to enter into a franchise agreement, right? We do that for all of our other utilities, electric, cable, everybody else. But way back when telephone lines were going up, the state legislature said, no, you can't charge rent. You have to allow them to go in your right-of-way. So by state code, they're entitled to be in the right-of-way. Helpful, though, is 7901.1, which says, okay, regardless of what 7901 says, the cities, you still have a time, place, and manner restrictions, right? And it all comes back to time, place, and manner. So the significant gap analysis doesn't apply to the right-of-way. Right? What applies to the right-of-way is the least intrusive means portion of that analysis, right? So we can require that if they're installing in the right-of-way that, we can have, consistent with state law, we can have certain time, place, and manner restrictions, such as we don't want extra poles to the extent we can prove you don't need them. We want you to go on our existing infrastructure. We want you to go on our existing light standards, on the existing utility poles or whatever else may be in our right-of-way, but those would be the most common place to put new antennas would be on the existing infrastructure. So our analysis when it comes to right-of-way installations is limited to that. Now, this is a little bit different because planning commissions, typically their jurisdiction stops at the property line, right? But what's the difference? The way we look at it in a lot of communities, like what's the difference if I put a wireless installation on this pole that happens to be on this side of the property line versus the visual impacts if the pole's on this side, right? So oftentimes we do have right-of-way ordinances that still send to the planning commission applications for installations in the right-of-way. So I didn't find it unusual that you guys had that in here, because one of the best bodies to determine aesthetics, right, is our planning commission, because that's sort of their wheelhouse,
I'm sorry, how does that relate to underground utilities? In other words, I know there are communities that require utilities to be undergrounded.
Well, because antennas cannot go underground, it's not technologically feasible for the antenna to go underground. What the undergrounding utility district will require of that proposed facility is that any of the boxes, meters, equipment go underground, but then the antenna is allowed to be installed on the light standard.
But I'm talking about the telephone pole. There are places that require telephone poles that don't allow telephone poles.
But those areas will have light standards, for example. There's been case law where NextG, which was a DAS equipment, they wanted to install all new poles in an undergrounding district. Ultimately, that got settled out. But there is a question about whether they're entitled to put new poles up. I think eventually a lot of the carriers have found that just using the light standards have been really effective way of getting their infrastructure in the right-of-way without resulting in massive amounts of litigation. Everything else, though, is underground. So what does time, place, and manner mean? Well, we can't have, interference. If they want to install on the right-of-way, they can't interfere with the public's use of the right-of-way, right? People still have to be able to get by. ADA compliance is a huge one. And if we obviously can show any other way that it interferes with the right-of-way, such as being, the legal word is the only word coming to me, incommode. So distracting to drivers, for example, right? Then we could say, well, you know what, you're interfering with our right-of-way. The code has said we can't allow discretionary permitting, which means that in the past we had some case law that said, we had to give them an administrative approval, a counter approval. The director had to be the one. We couldn't bring them to a public hearing and allow our planning commission to review it. But now we know that discretionary permitting is allowed. Again, we still have to meet our shot clocks, so assuming time permits, but that is allowed. We can require insurance, bonding, and indemnity, which we pretty much all know, compliance with our building codes, of course. And then, which is really key, is the City of Palos Verdes Estates case, which specifically found we could regulate right-of-way installations based on aesthetics. That was really key, because before they were basically saying that, there was a lot of argument that said, no, we couldn't, not under our time, place, and manner authority, that they said using aesthetics as the basis for denial was exceeding that authority under 7901.1, but this case came down and said no, aesthetics was appropriate for wireless installations in the right-of-way. So there's a lot of case law. You've heard me talk about a lot of case law. But this case, it's one of our more recent cases, and I just wanted to use it to give you an example of how this stuff is currently being litigated. It's a very intense area of litigation right now because technology moves so quickly. Cities' municipal codes, federal law, state codes, nobody can really keep up with as fast as technology is moving. And this actually related to some older towers. American Tower, it's a relatively popular tower corporation that manages towers on behalf of wireless carriers. They had 3 CUPs that expired after 10 years. Now, for a planning commission, that might sound a little odd because we're used to CUPs incurring vested rights and we can't expire them out. It just so happens that in the state of California, we can expire out CUPs for wireless installations after 10 years. Now, that may get overturned. There's a case pending right now, so they may overturn our state law, but fingers crossed we keep our 10-year expiration date, right? And American Tower confirmed that at the time. Now, in this case, these were some really old sites, and the city of San Diego wanted American Tower to update the sites to make it more aesthetically pleasing, right? Well, American Tower wasn't exactly helpful. They refused to consider modifications and design solutions that the city's planning staff actually suggested to them. They were trying to help them along, and American Tower just basically refused. The code, the San Diego Municipal Code, specifically required that the towers be minimally invasive. And this is important because the court said that you, the City of San Diego, and the Planning Commission acted consistent with local law, acted consistent with their governing municipal code by denying it because American Tower could not prove that the tower was minimally invasive. Right? And so when American Tower sued the City of San Diego prevailed on that issue, which was good for local entities. And then, of course, they had, I'm sure, a very qualified wireless attorney draft their resolution of denial because the courts found that was supported by substantial evidence and in writing. And therefore, they had met their burden under federal law. The effective prohibition analysis, you can't effectively prohibit, right? Remember we were talking about under federal law. Well, in order to establish that they've been effectively prohibited, like we said, there's a two-prong analysis. One, there's a significant gap, but they also have to show it's the least intrusive means. And that's when the court said, well, you didn't show it was the least intrusive means because you weren't working with the city to come up with better design solutions that were compatible or the minimally invasive installation under the city code. And therefore, you didn't violate the effective prohibition for, provision of federal law. And in that case, it's kind of interesting because, not only did the courts find they didn't show their least intrusive means, they didn't show alternate location analysis. We knew they didn't show alternate designs, but oftentimes as part of the initial analysis, you'll get an alternate site analysis where the carriers sort of look at different locations and then they say, well, here's the gap that we're trying to cover. We can go anywhere around here to fill that gap, and they describe for the city what locations they've investigated and why those locations don't work. That didn't happen here, and it's probably because they had existing facilities that they did not want to move or change. So there's a lot of case law. I just like this one a lot, mostly because the city prevailed. But that's it. All I have for right now.
Okay. Thank you very much. Any further questions, I'm sure? No? Oh, Gary.
I'm sorry. It seems like the best case for denial would be alternate site analysis and designs. Who has to do the alternate site analysis?
Typically, it's your carrier when, again, going back to an ordinance and a framework, as part of your application process. Along with the propagation maps, there's an alternative site analysis done as well.
To make an analogy, and you tell me if it's wrong. In this city, like you said, we're different. Everybody's different. We have a night sky ordinance. Okay, it's nice. And so, like when you look at when we talk about these light standards, when you talk about like street lights, put it on there. I think one of the subjective things is like, okay, you have a street light. Okay, that's like having one antenna. But if somebody put one of those stadium lights on that same pole in front of your house, you'd probably have an object to that because of the intensity of it. And it seems like that's kind of some of the concern, or this is what I sense the pulse of the communities, that concern of the accumulative impacts. And these are some of the, that's a subjective thing. And that is a reasonable concern to have. And that's why I think,
Well, I like your analogy. I think there is a way to objectively, look at that, ballpark light. We can use light meters to show the intensity in the amount of light that's gone up. And we can show light meters from interior to the home to show the light is spilling over into residences. There is a way to objectively take issues that the community has and be able to reduce that to a point where we can say we can put our finger right on this and put it directly into our resolution of denial. So it's definitely, but like I said, it's all fact specific. So if you're here, and I'm here, we can all come to a way that we can define certain things that we consider concerns, that we know the community is concerned about. It's just a matter of defining that.
Questions? No. Well, thank you very much. I really appreciate, we really appreciate your time and being educated a little bit into this area, very complicated area. Okay.
Well, thank you very much.
Thank you. Okay, well.
Oh, she could take my seat up here.
Yeah. Take all the seats. So then I guess we will, would anyone like a break at this point? Or is our heads a little spinning a little bit? Okay. We'll do a 5-minute break at this point, reconvene at 7:25.
No, I was just giving over norovirus. Oh dear, that's not good. No, it was.
Good evening and welcome back. We will continue now with our public hearings. The first item, aptly enough, on our public hearing calendar is item C1, which involves CPO number CPO 483 and UPO 421 concerning installation of an unmanned telecommunication wireless facility on Quintana here in Morro Bay. And I think Joan is going to talk to us about this one.
Thank you, Chairman Teft, and good evening, Commissioners. The first item before you that's up for public hearing this evening is a request for conditional use permit and coastal development permit approvals for a Verizon Wireless unmanned telecommunications antenna to be located on an existing utility pole in the public right-of-way and the associated equipment cabinet located at ground level around 1401 Quintana Road. The proposed project is located on the north side of Quintana Road to the south of Highway 1 and to the west of South Bay Boulevard. This image shows the project site and the existing utility pole as seen when driving along Quintana towards South Bay. Specifically, the applicant proposes to establish a new unmanned cell site to be co-located upon an existing PG&E utility pole. The project proposal includes the development of an associated equipment enclosure located at ground level adjacent to the utility pole, which includes remote radio units, an electrical transformer, a utility meter, and a shutdown switch. This is the site plan showing the proposed development. The red arrow indicates the location of the antenna atop the existing utility pole and the associated equipment enclosure located at ground level to the left of the antenna. It's important to note that the access doors to the equipment enclosure remain completely outside of the bicycle travel lane when fully opened, and they do not create an obstruction. These elevation drawings illustrate the proposed project. The existing utility pole with the antenna located on top of the pole and the associated equipment cabinet at ground level adjacent to the pole. These images show an enlarged view of the antenna attached to the extension above the top of the existing utility pole. The visual simulations show the proposed project site as it will look after development, and the small photo in the bottom left shows the site in its current state. I apologize, the small one is a little bit difficult to see. As part of the submittal requirements for telecommunications projects, the radio frequency report was completed and submitted to the city. This report evaluated the impact of the development on the surrounding area and concluded that the facility would operate well under the maximum limits allowed by the FCC, as detailed in the staff report and the associated exhibit. A post-construction compliance report has been added to the conditions of approval in Resolution 47-15. And in that report, it is recommended that training of appropriate personnel and the marking and posting of explanatory signage be posted at the site. So after review of the project proposal, staff recommends that the Planning Commission conditionally approve the project by adopting Planning Commission Resolution number 47-15, which includes the findings and conditions of approval, including the added condition related to the post-construction RF report and the site development plans that are dated November the 18th of 2015. And thank you. I'll be happy to try to answer any questions you may have.
Thank you. Are there any questions for staff at this point? Sure.
Do we have any photo simulations from Route 1, Joan?
No, sir, we do not.
It appears that the top of the tower is now above the road path at Route 1. Do you get a sense of that?
No, sir, I do not.
Other questions?
It's really hard to tell from here.
Joan, how wide is the right-of-way there? And how far does it extend past the power pole? Do you know?
I do not know exactly, not far.
Okay, so there wouldn't be an opportunity to move the pads further off away from the right-of-way, so it would lessen the chance of a vehicle running into it, or, lessen the impact, the visual impact of it?
Yeah, that's a great question. It has been moved back a little bit. Initially, upon their first submittal, it was a little bit closer to the street, and the doors actually opened into the travel lane, into the bike lane. So it was pushed as far back as it could go. And then the fire department also added conditions of approval with bollards and such, both from crashes coming off of Highway 1 as well as traffic traveling on Quintana.
Okay, so that's as far back as our right-of-way goes?
I believe so. I'm not entirely certain if it's as far as possible, but fairly close.
The plans show it right adjacent to the property line.
Okay.
So
Okay, good.
it's probably within inches.
Yeah, okay, I missed that, I'm sorry. And then on the color of the antenna?
I'm sorry, sir.
I'm sorry, the color of the antenna, it looks here like it's aluminum, brushed aluminum or something.
I believe so, yes, sir.
Could that be painted to match the power pole or close to it?
I believe so, yes, sir.
Okay. Thanks.
Joan, give or take 20 feet or whatever, what's the closest residence to this? Just roughly.
200 yards, if not more.
Okay, thanks.
Although I believe there's a proposed residential development across Quintana Road, fairly close to this site.
Fairly close, but still significantly far away.
Okay. Okay. There are no other questions. This is a public comment item, and we will open it up for the public to give us their input. We typically offer the applicant or applicant's representative opportunity to speak first. So,
good evening, Tricia Knight, representing Verizon Wireless. I wanted to say how pleased I was. That was a very informative presentation, even for me, and I've been in the industry for quite some time. So I even learned a few things myself. So I really appreciate that. I'm going to, for each of the projects that you're going to be looking at tonight, going to sort of present them within that framework that she did such a great job of outlining for you. And so one of the things I don't know if you've had a chance to look at in your packet is Exhibit A in the back from Chief Knuckles. So from the last time I was before you until now, we sort of went back and looked at how did we get to where we are? Why are we proposing these small cells the way we are in the city limits? And we learned that we were actually approached by Chief Knuckles last year. And I have the radio frequency engineer who was actually contacted by Chief Knuckles, and that is how that relationship sort of happened with reference to where the sites are and why they are where they are. Verizon currently has 5, 3 of which are before you tonight, and 2 others that are dotted around the city limits in order to accommodate the data needs that Chief Knuckles refers to in his letter. The fire department struggles, and so that is also in the realm of health and safety. And so this particular project, we looked at several different poles down this line, and as right-of-way sites are mandated by that utility, PG&E sort of tells us where they prefer us to be. And so we ended up on this pole because it had the room in the right-of-way for the equipment. If you see, we're sort of long and narrow along that property line. And so that is this project as it stands, how we got to have the need for it, as well as how we feel with this being the least visually intrusive. We can paint the antenna. I actually forgot to bring the revised photo simulations that show that antenna painted brown so that it does blend into the overall aesthetics of that existing pole. So, and I'm also available to answer any specific questions. I also wanted to reference on the last page of your RF report, which is your page Exhibit C, Figure 3, it just shows where our site is in conjunction to existing development and how the RF levels are compliant, and it sort of gives you an overall view of the site as it is in context to other structures. And then I'm available to answer questions.
okay. If you could stay with us,
Of course.
we'll hold all the questions till the end, until we hear from the rest of the public. And
course.
we may call you back.
Okay, that's great. And like I said, the radio frequency engineer is here. If any specific questions as the network or any other questions, he's available for that.
Thank you. Any other persons that would like to speak to this item, please come talk to us. Okay. Well, seeing none, then I'll ask for questions for the applicant or applicant's representative before we...
Ms. Nice, what's the purpose of the enclosure on grade?
The enclosure is for the supplemental equipment. There's radio units to help communicate to the overall network. There is a meter pedestal to provide power. So it's just the supplemental equipment to power that antenna and help it tie into the network as a whole.
Is the fence for security, or what's that
It
for?
was aesthetic. So ideally, well, not ideally, but initially we just had some above-grade equipment cabinets with bollards on the four corners. And so it was just sort of unscreened. And so we thought with sort of the rural nature of that road, that a wooden fence that weathers over time would be more aesthetically pleasing than just seeing supplemental equipment.
And did you try to make any ascertainment of the aesthetics from Route 1, or is it just from Quintana?
Well, just from Quintana, as the photo sims show that, as you can see that it dips down right there. So I've driven by and I'm not able to see that area from up above unless I'm straining, I would think. But no, we did not do any visuals from Highway 1.
Okay, thanks.
Yes.
Other questions?
Yeah.
Oh,
I'm sorry.
go ahead.
Okay. Is this location going to alleviate the dead spot on South Bay Boulevard?
Yeah, so this does two things. We'll go through each of the sort of basic needs of the sites as you review them tonight, but this is actually for coverage because if you are over on that side on Quintana, there really is nothing there. So this side, along with the others in conjunction with the city limits that you've been reviewing, sort of tie that coverage capacity together to help alleviate both those problems in not only this area, but to help tie into the network of the other sites.
As far as screening also, have you thought of any maybe some native planting, native plant material or something?
If you look on the page where you were able to see how close we are to the property line, there's
Right.
not a whole lot of area to landscape, let alone there's no water source, so we would have to bring in a temporary water tank in order to irrigate those to maturity's level. So I don't know if that's something that makes sense in the drought situation, but we hadn't looked at it just due to the proximity to the existing property line.
Okay. And on the street side, you've got a couple feet there where the gates open up, that this is set back. Have you thought about screening, any vegetative screening for that?
Same issue sort of
Same issue.
on that one side, so you'd have to have room for a temporary water tank. Right now, as our gates open, we are at the limit of where we would be impeding into the roadway. So planning staff had asked us to scoot back as far as we can and not have sort of anything on that side, let alone just including the fact that vegetation and the drought and that sort of thing.
Okay. Thank you.
Uh-huh.
I just, looking at the photo simulation, the ground equipment here looks bigger than some of the other installations we've seen. Is that just the photo, or is there in fact more ground equipment than at some of the other sites?
No, the way it's a lot of the configuration too, because we're in this little narrow strip. If that right-of-way sort of went back further into that section that's open, we'd probably be able to configure it a little differently, but because we're in that little thin strip as it's shown on your site plan, we had to go lengthwise. So it appears to be maybe a little larger because you're looking at it, it's longer than you're probably used to seeing. So on your Exhibit C, your A1 and A2 sort of illustrate that we're in one long line with our equipment due to proximity to the roadway and the existing property line next door.
Okay. Any further questions? Okay, so thank you very much.
You're
We'll close
welcome.
public comment and bring this back to the commission for discussion. Who'd like to start?
I'd just like to state that I wasn't here for the hearing 2 weeks ago on this, so
It was continued. We just opened for public comment
Okay.
and closed it.
Okay.
It was a noticing issue, so there really wasn't.
okay. So if it's okay with the rest
You
of the
didn't miss a
commission,
lot.
I'll vote on this issue then.
May I just make one recommended change before we
Oh.
make a motion? First off, I wanted to clarify the applicant's testimony with regards to this memo from Fire Chief Knuckles relates to the item on the calendar, which is under unfinished business D1. We are currently looking at the item, our public hearing that you've opened is the one on C1.
C1, yes.
And so with regards to that resolution, I have one recommended change. And that is under planning, this is your Exhibit A, planning conditions, paragraph 1. It's titled Antenna and Equipment Screening. It currently reads, as presented in the photo simulations of the proposed project, the fencing proposed as equipment screening shall be kept in good repair. And then I'd like to add, the canister containing the antennas shall be painted to match the color of the utility pole.
Very good. And before we get too far into this, I'll also ask for any ex parte communications that need to be disclosed. None. Very good. Okay. Thoughts? Catherine?
I have no problem with this one.
Jerry? We're all looking that way. So.
Okay. Yeah, I don't have a problem with this one either.
Michael?
Well, I think it's unfortunate we don't have any simulations from Route 1. That's our scenic corridor coming into town. We've had extensive discussions about the nature of Black Hill from this side. The development that went on the other side of Route 1 had massive amounts of aesthetic concerns that were accommodated in the design of that development. And I think if you look at the images, the cars on Route 1 are looking down over top of the enclosure into the silver equipment. And the top of this tower is easily, from the image that's on page 38 of the package, if you kind of have the capacity to blow that up, my estimation is that that's a third of the pole is above the height of the roadbed on Route 1 that's adjacent, and so this is something you're going to see. It's not an aesthetically gifted area because of all the utilities that are already there, but I think it's unfortunate that we don't ask for simulations where we have an asset like the entrance into town off of the scenic corridor. Quintana's not protected. We don't have a special obligation to that, but Route 1 is. So I'm a little disappointed we don't know what it's going to look like from Route 1.
Nothing? No? Well, I'm not thrilled with the prominence of the ground equipment here. But given the limitations, I really can't come up with a better solution, unfortunately. And let me just ask staff, the right-of-way beyond the pavement is substantially the same width all up and down Quintana. So going a little bit north or south wouldn't allow mitigation of the circumstance. Okay.
That's essentially correct. It doesn't change much. It's about the same. I mean, it does undulate some. I'm not going to say it doesn't. It does, but I think in that general vicinity there, it doesn't move much more than a foot or two, depending on where you're at.
Okay. So yeah, like I say, I can't really see how that can be improved upon. Sure.
Any one of you guys, could you tell me how far the city limit, where's the city limit go down to about? Like, does it go all the way down to South Bay?
Past South Bay Boulevard?
A little bit past, yeah.
There's a, you have the, RV and park past that, and it goes beyond that.
Okay.
So quite a, so beyond this site.
Yeah.
Pretty.
And Scott, this area, I should have done a better job with my homework, but this area on this side, not on the highway side, but the other side, this area is zoned for development, yeah?
It's Zone C1.
Okay, thank you.
Okay, well, if there is no other discussion, do we have a motion? I think we're working on it.
I'll move we accept, we approve resolution number PC 47-15 for the coastal development permit CPO-483 and conditional use permit UPO-421 with the added conditions.
We have a second?
Second.
Discussion on the motion? Seeing none, could we have a roll call?
Commissioner Lucas?
No.
Commissioner Sadowski?
No.
Commissioner Teft?
Yes.
Commissioner Lohr?
Yes.
Commissioner Sorensen?
Yes.
Motion passes 3-2.
Well, you can see there's not a lot of enthusiasm anywhere on the panel. Okay. Moving on then to item number C2. This is CPO-466 and UPO-412 for a proposal at 702 Morro Bay Boulevard. And again, telecommunications antenna. And again, we're going to impose on Joan.
Thank you, sir. The next item before you, as you said, is a request for coastal development and conditional use permit approval for a Verizon Wireless unmanned telecommunications antenna located on the top of an existing commercial mixed-use building with the associated equipment located behind the building at 702 Morro Bay Boulevard. The proposed project is located on the southeast corner of Morro Bay Boulevard and Piney Way, to the west of Highway 1 and to the east of Main Street. The proposed antenna shall be located approximately here. If you can see that bouncing red dot. You'll see the location more clearly in subsequent slides. Specifically, the applicant proposes to establish a new unmanned cell site to be located on the roof of the existing commercial mixed-use building, to be partially screened by an extension of the existing parapet. The associated equipment at ground level shall include remote radio units, an electrical transformer, a utility meter, and a shutdown switch. This is the site plan showing the proposed antenna located at the corner of the rooftop and the associated equipment at the rear of the building. You can see Piney Way along the left-hand side of the image, and Morro Bay Boulevard would run along the top. It is important to note that the hatch marks seen here on the rooftop illustrate the mitigation measure that has been recommended in the RF report to indicate public and occupational exposure limits. The hash marks are a little bit difficult to see. You can see them in your plan exhibit, but that large square would be painted blue hatch marks. That's the public limits, and this small square would be painted yellow and would indicate occupational exposure limits. These elevation drawings illustrate the proposed project. The top image shows the project as it would appear from the rear of the building, and the bottom image shows the project site as it would appear looking from Piney Way towards the east. These images show an enlarged view of the associated equipment located at the rear of the building. It's important to note that access to the rear of the building is restricted by a fence and a gate on both ends. The visual simulations show the proposed project site as it will look after development, and the small photos in the bottom left show the site in its current state. The existing parapet along the roof line shall be extended to provide a screening of the antenna, as I had said earlier. And here's another view. Again, a little difficult to see. As part of the submittal requirements for telecom projects, a radio frequency report was completed and submitted to the city. The report evaluated the impact of the development on the surrounding area and concluded that the facility would operate well under the maximum limits allowed by the FCC. A post-construction compliance report has also been added to the conditions of approval in Resolution 49-15. The radio frequency report recommends training of appropriate personnel, the marking and posting of explanatory signage, painting of the rooftop to indicate public and occupational exposure limits, and a rooftop barricade to prevent inadvertent access from the adjacent roof, which has been added as a condition of approval in your resolution, but is not yet shown on the plans, the physical barricade in between the adjacent building. After review of the project proposal, staff recommends that the Planning Commission conditionally approve the project by adopting Planning Commission Resolution number 49-15, which includes the findings and conditions of approval, including the added condition relating to the post-construction RF report and the site development plans dated November 16th of 2015. Thank you.
Thank you. Are there any questions for staff on this one? Catherine.
Was a significant gap analysis done for this project?
I don't believe so, no ma'am.
Maybe the applicant could speak to that more. Michael.
Joan, I know the building owner would have been noticed on this, but were the tenants in the building noticed on this, aside from any markings on the site itself?
I believe so, yes, sir. Owners and occupants within 500 feet.
Okay.
It's hard for me to say from the photo simulation, but what is the color of the antenna?
It's beige.
It's beige to match the building?
Yes, sir.
Okay. Almost, I think a point of discussion was it might even seem better if it was painted a black or a dark to more resemble a chimney. But I think the commission should look at that. And then it mentioned coaxial cables and would be painted to match the building. Where will those coaxial cables be ran, and why can't they be run internally?
I will find you a picture here. Let's see. So the cables go along the rooftop and down the side. You can see in the top image, right about there at the corner of the building. And you can see them run along the top here and over down along the side and down in the corner to access the equipment cabinet, as well as an existing utility pole, which is located back here along Piney Way.
So will they be visible from either of the street locations?
I don't believe so, no, sir. On the edge of the building, I believe you may be able to see this one coming down the edge of that back corner.
Okay.
You won't see it from the street.
And then, once again, my valley.
There's one that goes here to an existing utility pole. There's one that goes down. Oh, I'm looking at it wrong, but I pointed to the wrong one. It's that this one might be visible from Piney Way.
Okay. And what is the backup storage capacity? The time limit on that?
I do not know.
That's okay. Thanks.
Joan, what's the nearest antenna to this one? Do you know, possibly?
I do not know.
Okay, so I will again ask for any ex parte communications that need to be reported. None? Seeing none? Then we will open this. We will open up the public comment period. Again, we'll ask the applicant to speak first, and then whoever else would like to.
Good evening. Once again, Tricia Knight, representing Verizon Wireless. I did want to clarify, even though the letter from Chief Knuckles was attached as part of the next item, Chief Knuckles did submit this letter as evidence for him asking Verizon to pursue strengthening the network due to lack of data, and that does pertain to all the sites that you are looking at this evening. So that is that justification for gap, and it's actually capacity on this one, not coverage. And if you have specific questions, like I said, the engineer can probably go into a little bit more detail about why sites were chosen to strengthen that network as referenced in that letter. And then I'm available to answer any specific questions. The equipment is in the back alley. If you look on your site plan page, I believe A2, it is in the back alley, and so the cable will be coming up the back wall and then up over the top onto the flat roof. So it really is not visible from the street because it's in the back corner. And then our aesthetic vision here was sort of to have it look like a vent pipe that you typically see on rooftops. So we can paint that a color. We can also put, a vent hat on it, sort of, you would see on a vent pipe. So there's those aesthetic considerations as well.
Okay. Very well. So again, if you can hang around for questions, we'd appreciate it.
Of course.
Anyone else, any other members of the public who would like to speak to this? Please.
My name is Joan Graffia. I'm a recently moved to Morro Bay. This is a fascinating experience. Just a couple of questions. Does the applicant provide technical information or support that the height of the device is minimal as opposed to optimum? And then the other thing is, I would imagine the consideration as to what the view is from street level, somebody walking or sitting. So there was any thought to putting the device in the center of the roof square footage rather than at either end? I see a smile, so it's probably an obvious question that was asked and answered, but that's all I wanted to contribute.
Thank you.
Hi, Ann Travers, 595 Anchor Street. You asked where the closest cell towers are. St. Peter's would be the closest one 4 blocks away, and then the one on the Presbyterian Church that is proposed would also be 4 blocks away.
Okay.
Thank you.
Anyone else? Okay. I'll continue to leave the public comment period open for a few minutes just till we address these questions, if it's okay, regarding is the height of the device minimized, and has consideration been given to a less prominent location for the antenna? And you two can collaborate on this.
Will you answer the placement one, please? Thank you.
So they did propose the antenna more towards the center of the building, which was not a better look. It was sitting there in the middle, like that. This at least is in a corner adjacent to a parapet with a tree in front of it. So less visible from the surrounding area. The other one would have been much more visible, and again, it was in the center of the building, and there's no parapet around the middle of the building, just on the ends, and so there wasn't going to be any screening for it in that shape, that form. So we asked them to move it. Staff did.
Okay.
So don't blame them.
And as far as the height, is this the minimum height necessary? Either one of you can address this.
Yeah, it's height limit in the zone is 30 feet. It's at 26 feet. It's significantly under the height limit in the zone.
Right, for the zone.
Yeah, and as an RF engineer, we would prefer to have optimal for us would be above the trees, because the trees do create a certain amount of shadowing. You always want to have your antennas above any near field ground clutter, which would be trees and buildings. So optimal from my perspective would be about 5 foot above the trees. So I think it's pretty minimal. It's about as low as we can get it to the roof. As you move towards the center of a roof also, there's a certain amount of geometry. An effective site works much like an effective light, okay? If you go to the center, you're going to have a certain amount of geometry as to where it's going to come down. As you go towards the center of a roof, you want to go up. When you go towards corners of the roof, you can bring the antenna height down, because you can see off that roof more easily. If that makes sense.
I think we have another question here.
Yeah, while you're at the podium, just for my general information as an RF engineer, what is the exposure level? So when you're speaking on your phone with this next to your ear and you're transmitting, as opposed to the near field or a far field exposure from one of these antennas?
That's a great question. The reason most of the studies, the RF studies that you'll read, are done on the devices is because of the proximity, how close you're holding them to you. RF drops with the square of the distance. Technical, but what that means is every time you double the distance from an antenna, you cut the power in half twice. Okay? So if at maybe 100 feet from the antenna, the signal that you'll see from a cell site will be less than what you'd normally get from a device held up to the side of your head. That's the reason that the majority of the studies have been done concerning the devices. It's a stronger RF field that you get when in close proximity. Now, offsetting that, okay, one of the reasons we as engineers prefer to put antennas distributed around through a community is the closer you are to a cell site, the more your phone power is down. Okay? That's that is the most significant RF emissions that people are exposed to, and those can be reduced by being closer to a cell site.
So your cell phone powers down. The more towers the more cell sites that we have in the city will essentially give more people less exposure to RF than if we have minimal sites, large sites on the perimeter of the city.
Correct. And the way Morro Bay has historically been served from a ridgetop a couple miles north of town, phones in Morro Bay have always been powered up to the max in order to reach that cell site. We moved a couple hills closer with our new cell site, but it's still a mile and a half from the users, so the phones are more significantly powered up. As we can get these small, lower-powered cell sites distributed to the community, that'll really increase the amount of capacity that we're capable of carrying. It will improve battery life of the phones because they're going to be transmitting at less power. So that's a little bit of our thought process and why we're doing some of the things that we're doing here.
Okay, and as far as medical exposure or results from RF exposure, how does duration come into play as opposed to being exposed to a low RF field, say if you're living a couple hundred feet away, as opposed to a higher intensity, lower duration?
RF exposure is a function of both. It's a function of the intensity and the duration. So, for instance, when we're working on cell sites or working around cell sites, I don't have a problem walking in front of an antenna at a foot away, even though that's inside the area that the FCC requires us to mark off and say, okay, this is a warning area. I'm limiting my exposure how long I'm in that area. Would I stand there for 15, 20 minutes? No, it could cause heating of your body if you did. RF exposure is overkilled many times. We're a company that, entire industry, that has pretty deep pockets. We don't want to be sued. So when we calculate these numbers, when I provide the numbers to the third party that does the work, I give them the maximum. I say, this is the maximum power this thing could possibly ever do. They then assume that it's powered to the maximum all the time. That doesn't happen because some of your users are normally closer to cell sites on far different power levels, just like the phone powers up and down based on how far the user is away. The cell site powers up and down based on how far the user is away. So the closer the user are, the less power is required to talk to the user.
Okay, great.
So-
Thank you very much. I appreciate that.
Sir, could you
while you're
please
here.
state your name for the record?
Sorry, Dwayne Bonham, RF engineer for Verizon Wireless.
Thank you.
While you're here, just one more question, or at least one more question. Could you just define a little bit what the gap in service is that this particular antenna is intended to fill?
The gap in service, and this one is mainly a capacity. Now, all cell sites serve particular function. They're all going to be somewhat coverage and somewhat capacity. Just the nature of the beast. Even when we build one that's out there and we have no service, it's going to provide some capacity. When we build one in an area that's got historically good coverage, lots of times we're doing it for capacity reasons, but it's still going to give improved coverage. Okay, this one is mainly a capacity site. The distant hilltop that we've been covering Morro Bay from, and also Los Osos, overloaded 34 years ago. We searched for a site in downtown Morro Bay, unable to locate any sites in downtown Morro Bay, so we moved a hill closer to a PG&E tower where we built a site, I believe it was last year. That increased us from one sector, 1/3 of a distant cell site covering Morro Bay, to 2 sectors of a closer site that are now covering Morro Bay. Data usage grows at approximately 100% per year. That's one thing we're struggling as a company to keep up with. Every year, the amount of data that our network has to carry doubles. So going from one sector that was overloaded, we put 2 sectors there. We're doing some optimization to balance stuff out. We're still overloaded. We're beyond the capacity limits of what it can carry. So what we've done is we've chosen some areas where we have got mixes of residential and commercial areas. In this case, we have several hotels in the area, okay? We know that travelers, tourists, people who stay in hotels frequently use their devices for a variety of means. They take up a certain amount of capacity that we use for the residents. So we want to take some of that hotel traffic, offload that from those overloaded sectors. We're also, some of the other projects you'll see, we're trying to offload some of the residential areas also so that we can balance things out and maximize the amount of capacity that we can get out of the design of Morro Bay as a whole.
So if you'll forgive me for probably a stupid question, but if the issue is primarily capacity, why couldn't that be solved simply by putting a second antenna where you already have an antenna at the same site?
It's a good question. We currently have 2 sets of antennas there covering it. You can't overlap coverage. It interferes with each other. So you can't just simply add more antennas to an existing site. The number of antennas really doesn't impact how much capacity you get out of a site. The big factors are how well, let's say normally a site has 3 sectors surrounding it. How central is that to the usage? How well is the usage spread amongst those 3 sectors? In the case of that site that we just built north of town, 1 sector shooting up a canyon really doesn't provide any capacity. 2 of the sectors are providing capacity to the town. Okay? Trying to split that to a 3rd sector, the more sectors you put in, the more overlap you have. It's a diminishing returns. That creates more noise, which then prevents them from really adding capacity. So it's one of the balances that we have to do. When your sectors start overlapping each other, the area that's overlapped it has high noise and therefore is not effective at providing capacity. Hope that
Okay.
makes sense.
Yeah, it does, I think. Catherine.
This is for Ms. Knight, and maybe you too, but I really appreciate that you shared this letter with us from Chief Knuckles. In response to his letter, which in reading this, that he reached out in June of 2015, at that point in time, did your company go ahead and do a significant gap analysis of Morro Bay in order to decide where these would be most optimal? And if you did, has that been presented to this city that we might be able to take a look at?
I'll go ahead. The conversation was between Dwayne and the other entities of Verizon. I do know in speaking with Chief Knuckles that if you look at the letter, it does indicate that there are problems with that communication system throughout the entire city. I brought an exhibit that shows, and I don't know if there's an overhead capability, but how these are really freckled around the city, the 5 projects that are whose goal is to help eliminate that, not only for emergency services, but for the citizens of Morro Bay. And so they're not concentrated in one area. That was the least number of sites to alleviate that need of emergency services, as well as strengthen the existing network that Dwayne was just referring to. So that analysis was done, and we've talked to staff about it, but there was no, what's the right word? We choose the sites that meet the criteria, which is can we construct it? Is it a way that radio frequency engineer can get what he needs and serve the public and emergency services? Can we reach a lease agreement with whatever entity that may be? And so all those factors have to come into play, and then that's how that one spot is chosen, as well as being the least visually intrusive.
Ms. Knight, it looks like we do have an overhead, if you'd be happy to share that with us.
Oh, hold on. I think it's over here. Sorry.
So when I was originally contacted by the fire chief, it was that they had lost capability to communicate in the city of Morro Bay, and he wanted me to come to a meeting and know exactly what Verizon was going to do about it and when. At the time, we had some projects already out there. We knew we already had a problem. We were very well aware. We get statistical reports that show us where we're overloaded in our network. And we're trying to look usually about 2 years ahead, because that's really how long it takes from the time I put a dot on a map, say I need to build something in this community here, and when the best case scenario, it's 2 years before we can turn something up. So with that long lead time, we're looking usually 2 to 3 years into the future to try to figure out where we need. At that time, we were already 2 to 3 years behind in Morro Bay. So now we're trying to play catch up and get some projects out there that can alleviate that overload that currently exists.
Could you point out the different areas?
Of course. So each of the pins is a Google map, and we just plotted the existing projects that you're reviewing as well as 2 others. And so there's 6 total. And as you can see, they're peppered throughout the area of need. And in speaking with Chief Knuckles, it's that GPS communication system that they use, not only communicating within the city, but during emergencies between each of the overlapping counties that's struggling. And so as Dwayne was analyzing that need, that gap, if you will, even though a lot of it is capacity, that's why you're going to see they're dispersed. They're not localized in one area so that they don't each struggle with capacity. These are sites that are going to help offload those overwhelmed facilities that are outside city limits. So I hope that helps to answer your question.
Yeah,
it's a little difficult to see from here. If you could use the pointer, maybe Joan, you can loan her the pointer and kind of go over the different ones.
So here's the one that you just recently approved. Sure. I get to try to use my technical skills here. Okay. So here's the one that you just approved. This is one that is another JPA pole just outside the golf course that we were working with the city on, and there was a pole that didn't turn to work out very well from public works standpoint, so we'll be resubmitting that application on a pole upon the city's suggestion. Sorry, I don't have my glasses, so I'm going to have to sort of go back and forth here. This is going to be on the Hungry Fisherman rooftop, and then and so 702, let's see. Okay. This one here is the one you're considering. No, that's the one we're going to be considering next. This is the one you're considering now. And I have to look back. So as you can see, here's 1, 2, 3, 4, 5, and 6. And here is the area that we're trying to offload from. You've got a, on Radcliffe, which is where here, there's a PG&E tower, and then further out of this view are the other 2 hilltop sites that are currently serving Morro Bay. So 6 small cell sites total to offload that capacity and to address emergency services concerns. Oh, sorry, standing too far away. So 6 cell sites total to help offload that capacity, to help out the needs of emergency services as well as the Morro Bay citizens.
Thank you.
You're welcome.
Just quick. Does staff have a map of these sites and then sites for the other carriers also that can be, superimposed on this? Or
We have a list. We don't have a map.
okay.
Michael.
Ms. Knight, do you have any plans for the north end of Morro Bay at this point?
I'll go ahead and defer to Dwayne on that.
This is everything I can afford to do in Morro Bay right now. So, by north end of Morro Bay, which are you're referring to?
Well, this is about half
Off the map
city.
of Highway 1?
Yeah.
Okay.
Toward-
We have our current, the Morro Bay site that we've historically served Morro Bay with is up there above that portion of Morro Bay. Now, there is an area right as the hill drops off where there are some coverage issues that we know where there's a shadowing effect created by the hill for some of the houses that are going up the hill. I currently don't have a plan for that. That would be on my wish list, but I haven't kicked anything off there yet. So.
And can you tell me, were there any discussions with the city about the fire locating one of these on the fire department itself?
No, there wasn't.
Okay.
Thank you for your explanations on this, Arf. It's very good. One of the issues with this site is a capacity, because of the capacity deficiency that you have. Is this, what I see is like a building of an infrastructure. That's what we're doing here, right? Building an infrastructure and, these one-off permits. But they're all integrated as they work in an integrated fashion, correct?
That'd be correct, yes.
Now, is this capacity issue any way related to potential smart meters for PG&E or gas or water meters as far as having that information going through there?
No, PG&E, I actually worked on that in the early days of that with our company. PG&E originally was looking at utilizing our network for smart meters, and they decided to go a different direction and utilize their own network for that. No, it does. It has no ties to smart meters.
Okay, so this particular doesn't. Okay.
No.
However, smart meters would need antennas similar to this, whoever would be doing this, correct?
PG&E, I believe, uses antennas, and then the smart meters daisy chain and talk to each other in order to venture out from their antennas.
Okay,
so
I see.
I'm not an expert on their network. I know a little bit about it, but Yeah, it doesn't work on the Verizon network.
Okay, thank you.
No? Okay. Then we'll close public comment. Thank you very much. And we'll close public comment, bring it back to the commission for discussion. Michael, would you be willing to start out?
Sure. Yeah, my recollection is we approved a site maybe a year and a half ago on a pole north of or maybe east of the green triangle. My recollection was somewhere around the what used to be the golf store, a carpet store up there. There was a pole up there that I thought we approved, and then we approved the block just to the east of that last week with the new rooftops on the building on Quintana, and then St. Peter's is about 3 blocks away east. The Presbyterian Church is another block away east. So this idea of the network going on here, when we talked about 4 or 5 of these last week, I thought that was for all of Morro Bay, and it's really just for the southern part here. We have a geographic section that's longer than that to the north that has hotels and things in it as well. So my sense is we just don't have a good handle on this combinative infrastructure that's put here. We don't have a good handle on where the existing facilities are of the different people, different providers, and I'm just very concerned that we just keep attacking it piecemeal. I don't have any particular concern about this one, except when you actually look on the Google Map version that I'm looking at now in real time here. I was kind of shocked how close this is to the one we just approved last week. It literally is about the length of the green park is about how far the one we approved last week is from the edge of the green park, the little green triangle, and then this one is just across the street. So this matrix of provider cell coverage is pretty invasive, and that's all I want to say.
Richard?
What I feel is happening here is, and it's not necessarily this one particular one, but it's kind of like if you had, if somebody wants to do a development, right? Like, I want to build 5 homes. They might have to need a minor use permit or whatever. There's a continuity to it. Could you supply the water, the sewer mains? Are they big enough to handle this development? We look at these things as a integrated project. What I see is the building of an infrastructure with no parameters, and that's why I'm having a hard time. I'm not necessarily like picking on one or this or that. It's the lack of, I guess you put it well, piecemeal, the lack of integration when we're looking at it all together. And not only Verizon's issues, but other things that we're going to. And as a commission, we have to be, lawful. That's important. But we also have a subjective part of it where the health and safety and concerns of the community and what they feel. Now, we have a letter here from a gentleman that lives near there or around there. I take to heart there. It's like, the federal government might say this is not an issue, but you know what? It's an issue to him. And, and that's who we have to be considerate of. And I just can't help but to think that if we had the right tools, in administrative tools to do the job, this almost would be, okay, no problem, okay? But we're not there, and we need to be there. High time we were there. In fact, there was a email, I think, and somebody was talking about, I can't remember who it was from, but 2010 or something, there was a discussion. You know, this is long overdue. And it's really not fair to the applicants or the people that are concerned here, you know.
Jerry?
Well, my first thought is we need 72-hour emergency backup power. I'm a broken record on that, but, you know, once again, after an earthquake, it's, you know, we're going to be the last one to be serviced. So if these towers are, or if these cell sites are important on a normal everyday occurrence, then they're important in an emergency. And this is an emergency backup system. So that's why I harp on that. So I would like to see that included, unless it can be deemed infeasible. So I would like to see that as a standard condition on all cell sites, you know, that are brought forth through the city. I would also like to, you know, we're creating a network here, and we're creating it with breadcrumbs, where we should be looking at the whole, to mix metaphors here, the whole spider web. So I would rather see, rather than these sites coming one at a time and us trying to determine how they work in synchronicity, I would like to see a 2 to 5 year plan of what's here, you know, what are the projected needs of the community, and how are the various carriers going to, provide for those needs, so that we could do an overall plan for the city. And I would like to ask our in situ lawyer here that do we have the capability of asking for that data so that we can do proper planning?
Yes. There are many ordinances, and I'm sure Verizon will tell you, are tiered, right? And one of the tiers can be a master permit. So 2 to 5 years is probably too far out. I mean, I can defer to the RF engineer, but because of the way technology changes and the demand changes so quickly, 2 to 5 years is probably, we'd get a lot of opposition from carriers. In the tiers where they require a master permit, it does require the carrier to submit a citywide deployment plan for all installations expected, like in the next 12 months, for example. That way, the maps that come in show the existing sites. It shows where the new sites are proposed to be installed, and all of those sites are reviewed together. In some ways, they're more efficient because rather than having to come back to the Planning Commission separately, they get one permit for all of those sites.
It seems, he mentioned, he said that he's planning 2 years out. Mm-hmm. So if he's planning on a 2-year wish list, it seems like at least, we could be seeing a 2-year wish list on that too. And it would, and once again, it would make a much more condensed permitting process that we could look at the network and say, yeah, this is reasonable, or maybe we want to move this one over here, or something like that. That's kind of where I'd like to see this process go if we could, but that's my personal opinion on that.
I would absolutely agree, and if we were to move forward with an ordinance, that would be what you would see.
Okay.
I'm very uncomfortable going forward and approving additional cell tower units without at least a master map. And I think we talked about this 2 weeks ago, that we really needed a master map of not only the Verizon. I appreciate that that you brought that for us, Tricia, but I'm talking about all the other cell sites that are already in the city. And I think that again, it's shotgun. I mean, it's not a well planned out. Not that it's on the side of Verizon not well planned out. I'm sure it's very well planned out on yours. But for a city, I don't think we're making decisions based on a plan. We're making decisions based on individual events, and I think that gets very dangerous in the long run. And I just think that it's important, and it's not this necessarily site, because actually I think it's relatively unobtrusive, and it probably wouldn't cause a problem, but it's when do you get the next one and then the next one, and I have angst over it.
Well, I mean, it's impossible to be against planning. I mean, that's what we are, the Planning Commission, right? But I have to say, realistically, if Verizon gives me a 2-year plan, and AT&T gives me a 2-year plan, Sprint gives me and whoever else, T-Mobile, gives me a 2-year plan, and says, here it is, evaluate it. How do I evaluate it? I don't know. I don't know how to identify a significant gap in coverage. You know, I don't think we have anybody in the city that in the city's employee that can really evaluate that. And then what basis are we going to evaluate it on? Because we don't have an ordinance. We don't have something that says this is what you look at when you get an application for a cell site. We do know, and we've been told, the one thing you can't look at is RF. So I don't, what we would be looking at, whether the colors all matched or whether the heights were all the same. You see what I'm saying? In other words, what are we going to be looking at that's within our purview from one cell site to another to say this 2-year plan is okay or it's not okay? I mean, I think it's great to have the information. I think to know where each of the companies are going, but I just don't know how much we could weigh in on that in terms of the technical details. Personally, I couldn't. I just don't have the expertise or the training. Sure.
Just as a rebuttal to that, Chairman Teff.
It's not something to be rebutted. It's really a question.
Yeah. What we can weigh in on is, I can't match him as an RF engineer. I really appreciate the information he gave us tonight. But what I can weigh in on is that is this company placing one cell site the next house over from the other one? If we had a 2-year map, we could say, okay, these need to be co-located on the same rooftop, so that it minimize, and then they could be screened, so it could minimize. Instead of placing 2 in, then we could have one of the companies move them so that they could work together.
But when he was talking about interference between 2 antennas, I heard him.
Different radio frequencies, different spectrums.
But you see, that I don't know. I don't know. That's what I'm saying. I don't have the expertise to say, oh, these could be co-located or these couldn't be.
Well, you have, on the top of Radcliffe, they're co-located with AT&T and Verizon and that other data company. So there are antennas that are co-located on one site there. So if we don't have that information, if we don't know that, we can ask the engineers that come to propose that. But if we have a master map, then I don't know that there's not another site. There's not a site on the building next door to this. I just don't know. And so that's where my concern is.
I guess we could at least ask the applicant to evaluate it and give us a report as to whether it would be possible or not possible.
Yeah, is there additional information? So we're talking about two different things, right? We're talking about globally preparing and putting together an ordinance that deals with how we approve these things in the future. That's one thing. That has nothing to do with the applications before you this evening. That's a concept, right? So is there anything that you'd be interested in? I heard the map thing about other sites in the area. We've looked into this a little bit, and why you didn't get something from staff is all the maps that we found were inherently inaccurate to this point. So that's why we didn't give you something that we knew to be wrong. So we didn't know. It might have just been the resources that we looked at, and maybe there are other ones that are accurate. Just the ones that we saw were pretty patently incorrect. And so we weren't going to present that to you because I wouldn't have given you any real information. So we could probably go do that, and you could request that of the applicant maybe, and we could work with them to do that. My other question would be, is there other things that you would like us to look at as it relates to this? Kind of taking the temperature of the group up here. Is there other things that you might want us to go back and look at if you were to maybe continue this item or something?
Well, one of the things I would like to see is I'd like to see what's the potential for us locating these on city property so that the city can gain revenue from it rather than scattering them out throughout the city in private residences.
We have no ability to force them to locate on city property.
Not to force them, but that's one thing that we could look at in our ordinance to encourage that.
Certainly. From an ordinance standpoint, yes. I was really trying to maybe see if there was concerns in general, and then more specific to this, and I was wondering if there's additional information that we could maybe bring back to you that might make a decision on this item easier, more comfortable. I don't know, something like that. Yeah.
Well, Scott, in the packet you gave us a nice little charter, the applicant did, on the rooftop. Okay, it's yellow here, it's really bad, and then it goes to different colors out. And I'm envisioning a significant gap analysis that shows, and I'm sure they had to do it, that shows, okay, it's really strong here, but it weakens, and this is the cutoff where you're going to drop something or the data will be decreased significantly. And if we put it here, then that's going to overlap it. And I'm sure this work has been done, or they're not going to be able to say that it should be here or it should be there. And I think that's an important thing for us to see. And, I trust that Verizon has done that, or they wouldn't have been picking these sites. But I think that's something that would give me a little bit more comfort in approving these cell towers.
Okay. I think it's probably information that we can put together, and if you wanted, you could ask the applicant to come up and gain their concurrence if you'd like.
Okay. Yeah, we'll open public comment for the answer to that question.
Thank you. So one of the things as we go through this application process is when we submit information and then we work with staff to help them come to their determination, then our application is deemed complete, and then we move forward to the hearing stage. And so all the things that we're talking about since the last time I was before you are things that I believe are going to be considered in the new ordinance that is even currently underway. Has anyone ever seen the ordinance that's in play right now? It addresses a lot of your concerns. And it actually outlines changes that were proposed that they were in with your general plan amendment, so they got sort of stonewalled. So, but the current applications that are in front of you right now, there were nobody staffed. The ordinance doesn't state that we need to provide those exhibits. We worked with staff answering those initial questions. But right now our application is complete. It's really not going to change too much because we've brought it to the lowest height feasible, least visually intrusive. We showed we're compliant, and we show a need. And so I am hoping that you can take the information that we have given you so far, and as we're going to have 2 more applications coming down the line, and at that time we can work with staff to say, here's that overall network that you were, or however they want to overlay all the existing cell sites. But we've had this one in play for a while now, and we're complete, and we're before you with as much evidence as we can give you as Verizon alone. You're asking for more in-depth information as you go through your ordinance amendment to make sure that you have those tools moving forward. Us as the applicant are working within the constraints of your current ordinance and what staff had asked of us, applications complete. And so hoping that you can make a decision. If you choose to deny us, that's one path. But we have gotten to this point, and our shot clock is ticking. And so I just encourage you to hopefully be able to make a decision on this project. The other two that are going to be coming that we haven't submitted, we can go a whole nother way. You'll have more tools, or staff will be able to say, hey, we want X, Y, and Z now, because we know the commission wants that. But to continue us right now and go backwards is sort of hard for the carriers to understand, because we've gone all down the proper paths that we were given. And so that's just my only comment on that.
Well, it seems to me, I mean, we've gotten a heck of a lot of information tonight, and it's a little bit hard to digest it all. But if I heard Ms. Lopez correctly, there really are two bases, two things that we have to look at, and that is there a gap in service? You know, and I guess the question I would put to you now is, does the letter from the fire chief establish that we have a substantial gap in service with regard to their needs? And then I guess, is this minimally intrusive in terms of the visual impact? If I look back to the sort of the things that would disqualify it under federal law, would be if those two things were not met, if there were not a significant gap, or if this was not being met with the least invasive measures.
I would add that related to the fire comment, we had our Development Review Committee meeting this morning, and Tom Prowse is the fire marshal for the city, and indicated that this application specifically would solve one of the issues they have for coverage for their units, so for the station, if that helps.
Well, unless there's further comment, I would move on a resolution, but
let's see.
I'd like to make one more comment.
Yeah.
And it's response to your comment, Chairman Taft. And this is no way discounting what Chief Knuckles has written. When he wrote this is somewhat global. It's global about Morro Bay. It doesn't show off cutoff areas. And the additional information that you gave us on this individual one would solve a problem, but that's anecdotal. And I'm okay, I'm certainly okay with it on this one, but going forward, I would like something that isn't just anecdotal. I would want something a little bit more concrete in order to make a decision.
I would say, staff has listened to you carefully in the comments and the concerns that you voiced this evening. And I think, to some extent, and even working with the city attorney's office in altering our applications to reflect the shot clock issues, having carriers identify which one they think they fall under, and adding some of the requirements like this to the submittal checklist for wireless facilities, I think will be helpful. And in speaking with Ms. Lopez, she'd indicated that she might be able to get something to me as an example within a week or two that she's working on for other clients that they serve. So that's something that we probably put in place right away, and we could probably improve the level of submittal that you're getting moving forward, and then we'd have to look into this sort of parallel process of developing an ordinance. The city did that in the past, and it wasn't. And then when we went to go get it certified through the Coastal Commission, we were not successful because it lacked some of the components and had some things that were inconsistent with current law, state law. So it had a problem, or maybe federal. I'm not sure which. I'd have to go back and look at what it said, but it really said, hey, this was inadequate what we had sent to them. So again, well before I got here, but that was the response letter that we got from the Coastal Commission.
Yeah. Well, it's painful, but I think we're sort of making a little bit of progress on this. We're wading through it. Is there any other comment or discussion?
Before we make a motion, if I may interrupt, if we were going to move forward towards adopting the resolution, I did want to make some recommended changes, just for clarity, to address some of the concerns that were raised during the commission comments. My first recommended change would relate to planning conditions, paragraph number 2. The last sentence reads, the associated equipment and coaxial cable shall be painted to match the existing building color. Consistent with what the applicant said, I wanted to just reword that to say the associated equipment and coaxial cables shall be placed to minimize public visibility and painted to match the existing building color.
Right.
One of the other issues I did want to clarify with the commission, there was a question about the color of the vent. But assuming we are going to keep the color of the vent the same color of the photo simulations, I do prefer to add some language. This is the photo simulation that is Exhibit B, photo simulation view 4, which is the one we discussed. And I would have to defer to staff on where to put this recommended change. And if staff has comments, I wanted to turn it over to them and give them an opportunity to comment on the proposed language. But either planning condition number 6 or under building condition paragraph number 1, I wanted to add that the final building permit approval shall be contingent on approval from the community development manager or his designee, who shall only approve said installation if all equipment and antennas are installed such that the appearance substantially complies with the photo simulation submitted by the applicant.
Okay.
That's a good phrase. We could write that down and use that again.
Let's stick a pin in that one.
I think planning commission, planning 6.
Okay, so my recommendation, per staff's recommendation, is that we make that amendment to planning condition paragraph number 6.
Okay. And the question is, back to the vent.
Yeah.
And I brought this up, do we think that this would look better as a faux chimney or as a stovepipe sticking up there? We could have a chimney top on that would make it more like a like a spark arrestor for a real chimney, for a wood burning chimney or something. Michael?
I don't really care what it looks like.
It's a commercial building.
I'd go for dark
So we wouldn't
myself.
put a chimney on a commercial
Okay.
building. Can I comment that?
Okay, let's
May I?
go ahead.
I understand this to be a commercial building.
Right.
So we typically wouldn't have a chimney on a commercial building. So the above ground infrastructure that's more typical of this type of this kind of existing building would be a vent. We could take the applicant up on their suggestion that they put a cap on it. It kind of looks like an umbrella. It makes it look more consistent with what we've seen. If you want that, we can add that to the conditions. But I would. Without being here on site, my guess is that this color would probably be more consistent with a commercial building.
Okay, I can go with that. I'll concur with that. And then also the added condition of a 72-hour emergency power, backup power, unless it's deemed infeasible.
72 hours is a lot.
It's what we're required to fend for ourselves in an emergency earthquake.
Our standard full cell sites, we have 4 hours of battery backup and a generator so that where we can last out that. On these smaller capacity sites, that's a lot of space, a lot of real estate you're talking about for 72 hours of battery backup, because when those batteries drain and they have to recharge, that's a lot of amperage you're putting to it. Okay.
What kind of amp hour draw are you talking about on this site?
I'm not an equipment engineer, so I'm not sure. I know we have done some of these with 4 hours to maybe 8 hours of battery backup. Honestly, we've never done one with 72 hours of battery backup. We don't have a cell site that has, from a battery standpoint, 72 hours of battery backup. We have battery generator combinations that do 72 hours. Now, I also know that The FCC is looking at mandating us, and that's one of the reasons we're fans of building the cell sites instead of these small cells, is the FCC is mulling around federal legislation after the hurricanes down in Florida to have a standard for battery backup. What we do have the capability of doing is putting a plug-in for these, and this is one of the things we discussed internally because it is important. And with us providing the amount of emergency services that we do for fire, police, we have a company objective of making our sites as bulletproof as possible, to make them the most bulletproof in the industry, as a matter of fact, and we achieve that. But what we can do with these is put generator plugs in where we can bring out, and this is what we've been discussing with these smaller sites, smaller Honda generators that we can deploy, chain them to a pole, plug them into this mini cell and start those up, and enough battery backup until we could get such generators to any sites that are in a disaster zone.
What kind of draw does this site have? What's the current draw on it?
I think it's about 40 amps.
40 amps? Okay. 240?
At 120, I believe.
110?
Yeah, 110.
So you're talking about a 4,000 watt generator. You can get those that are natural gas powered that'd be about that size.
Small Honda.
Small. That I would be totally comfortable with a natural gas hookup backup generator on these sites. It's a small package. Not that expensive. You can buy them at Home Depot or Costco for those.
You can. Verizon, when we buy stuff, we do everything as well as it can be done.
Right.
So we don't deploy cheap stuff.
Yeah, I understand. But Honda,
when we bulletproof stuff, we bulletproof it.
Yeah, Honda 4,000 watt generator is not that hard to come by for a natural gas.
No, but doing each one, we normally do either gas or diesel. We do some natural gas now.
Right.
This is getting a little scratchy.
Yeah. It's getting that time of night.
We would probably prefer on these, though, to have portable generators. We're not doing one for each. We're deploying a lot of these across the state, and I've been with Verizon for 26 years now. I know I don't look it. But I've been through the Loma Prieta earthquake, the Oakland Hills fires up in the Bay Area, the Paso Robles earthquake. We're very good at getting resources into an area and deploying them, but we do like a little bit of freedom in how we do it.
Yeah.
Putting generators into these, generators are going to have noise issues. That's the citizens here. If we're putting one and we start talking about putting a generator in, they're going to have concerns with the noise.
Well, if we're talking about an emergency backup, this is in the sense of a tsunami or an earthquake. I don't think you're going to get a lot of noise complaints if you are getting noise complaints, it's because they're calling on the cell phone.
But they kick in on any power outage too, and we have to test fire them once a week. They have to be run once a week for about 15 minutes. Not a huge deal. We do it usually on Tuesday or Wednesdays about 10, 11 a.m. so that we're not minimizing the number of people that might be awoken by it. And we usually do very good quality, very quiet generators when we put them in place. But it would be a redesign of these sites. I think that's something that we could look at going forward, and I think it'd be something great if you want to incorporate it into you guys' regulation when you get it. But that's not what we have planned out and set out on this particular project.
Okay, well, if you want my vote on this project, then I'm going to require a 72-hour backup emergency power supply. So, as a condition, unless it's proved infeasible. So, and as an NABCET certified solar engineer, I do not see why you cannot do this. I have done this on homes too.
It might be good to just close public comment.
Yeah, okay. I didn't want to get into an argument. I'm sorry.
Yeah.
Okay, well,
Let me ask, are there other feelings from commissioners on the 72-hour backup issue? Is that?
All I got to say about that is when I was, the fire department's not the only ones that are first responders. I mean, the sewer guys are they call the sewer guys when there's a sewer problem. Anyway, we had have to take a truck, and we had to tow our generators to the lift stations, and we had to plug in there when I was on Cayuga. So I understand your concern, yeah. But I also don't. I could see that on something like that, maybe a mobile unit, just for like if there's a time constraint and stuff. But I'm not passionate one way or another that way.
I think it's important that there is backup generation, a way to do it. I mean, the plug-in where they could bring a generator would be fine with me, but I know that this is very close to Commissioner Lure's heart, and he brings it up at every meeting. So I think, I'd support it either way.
I think the generator issue is emblematic of the fact we don't have a policy, we don't have a goal, we don't have an idea about how to treat this technology right now. We're just getting piecemealed every time, and there is no coherent thing. On one hand, we've got all this demonstration about capacity, and then when we have a question about meeting the most basic needs of the city, which the chief wrote a letter about, we don't have consistency about what we want to have for that aspect of it. So to me, until we have an ordinance, until we have goals, and until we treat this as a planning thing instead of a drive-in window like a Wendy's or something like that, I think we're in bad shape on all these issues.
Well, I don't know. Is this something, Scott, is this something that if we used a more general wording such as, adequate provisions for emergency power in the event of a natural disaster, could you work that out at the staff level?
This is an interesting, issue, and I've thought about it actually quite a bit because Commissioner Little brings it up frequently, and Commissioner Stowski's comment about what we do with lift stations when we don't have power, like some we have hardwired generators associated with them. Others we bring portable generators and go hook them up. I mean, those situations are pervasive, not just City of Morro Bay, but countywide. So that is a common way to deal with those types of issues when you have, like you said, like a lift station or something along those lines. That's a common way to deal with it. Now, I don't know what Verizon's capability is to roll up a truck with a bunch of generators on it and deploy them in the City of Morro Bay in the middle of an emergency. I don't have that information. So that would, so I think if that capability exists on the part of Verizon and they could show us, then I think that idea where they just have it would be adequate, that they have the plug-in for the generator on it, if they have that infrastructure within their company to make that happen and what that looks like. Because then I think you're getting what you need. So I don't have that information though. So they might be able to provide that to us. They said, it's something that they look at, so maybe they do have that infrastructure in place, or maybe they don't. I don't know.
okay.
I can perhaps suggest some language as part of your conditions, which hopefully would be broad enough and acceptable enough to everybody. I'm scribbling these down as quickly as I can, because if I try to read it without writing it down, of course, I won't get it right. But what I'm thinking is a new condition under your planning conditions, probably somewhere before dust control, which is paragraph number 4, that read backup power. Applicant must ensure backup power to the wireless facility in the event of a loss of power. Said backup power shall be provided as fast as technologically feasible.
It doesn't talk about duration.
Yeah.
You know, because backup power, it can be an instantaneous, but only lasts for half an hour. And then, if they provide backup power for 72, you know, for a, you know, to drop off individual gen packs on each of these sites, then they're going to have them in inventory in the locale here, because they're not going to be able to transport them interstate. So this is going to have to be located in San Luis Obispo County somewhere, with the company having enough gen packs to service all of the cell sites in San Luis County if in a San Luis County emergency, in a situation where there's an earthquake. So why not just have them on site, ready to kick in when they're needed?
Well, the difficulty here is that we're only conditioning this particular site. So even if I were to condition this site to include backup generation and backup power for 72 hours, this site may be working, but the rest of the sites wouldn't be, since we're not conditioning all the sites to do that. So I think if we ask for backup power, I think that's great, assuming the applicant's agreeable to that. But if we ask for a 72-hour duration period, like the ARF engineer said, that's a little atypical for the rest of the sites. So I'm not sure how helpful it would be unless 100% of the sites were.
Well, so far we've conditioned several of the sites already to do that. So
just 72 hours?
Yeah, so the idea is to have each of these projects that come forward be conditioned for 72 hours.
So if I revise the language to say a new paragraph for backup power, the applicant must ensure backup power to the wireless facility.
There's some verbiage here. Minimum
This
has come up
backup
before.
power supply to the antenna in the form of a generator or other acceptable backup power source.
Well, I'm comfortable with the language we used for the last site.
I see. I didn't realize it was already part of your conditions. I thought we were adding it.
This is a different project.
That's an example of the condition that we did for the same thing to address the same issue from a different project.
In a different location.
Okay, so we'll add this
From the
paragraph.
previous project, I think.
And
it was.
I'm happy with that condition, and because I've been a pest on this for a long time.
So sorry, but if I could read that into the record just to make it clear
Sure,
then?
that'd be
Okay,
great.
so we'd like to add a new paragraph to the planning conditions. It looks like the best place would be prior to what is existing paragraph 4, dust control, to read a minimum of 72 hours of backup power supply to the antenna in the form of a generator or other acceptable backup power source shall be supplied and shown on building plans unless deemed infeasible by the community development manager.
I'm happy with that.
Well worded.
Okay, well then, with that those modified conditions, let me see if I've got the right resolution here. I'll move that we approve resolution number PC 49-15 for CPO-466 and UPO-412. Is that I'm hoping that's the correct resolution. Okay.
Okay, we have a motion. Do we have a second?
I'll second.
Okay, we have a motion and a second. Do we have any discussion on the motion? Then could we have a roll call, please?
Commissioner Lucas?
No.
Commissioner Sadowski?
No.
Commissioner Luer?
Yes.
Commissioner Sorensen?
Yes.
And Chairman Teft?
Yes.
Okay. Motion passes 3-2.
Okay, our third public hearing item this evening is case number UP0-359 involving proposed development at 725 Embarcadero Street here in Morro Bay. And do we have, I'm sorry, Cindy. Cindy is the planner on this, but I understand there's been a request for a continuance. Is that still correct?
Yes, that is correct. Good evening, Planning Commission. Just for your reference, I just passed out some correspondence. As is customary, I had emailed the Commission earlier today some correspondence received from Chairperson Teft. And if you did not check your email today, I just gave you a paper copy of it. So after the staff report was released for the conditional use permit application request, the applicant submitted to staff a request to continue this hearing item until the next Planning Commission meeting, which is Tuesday, January 5th, 2016. The request for continuance is based on their lack of availability for tonight's meeting. As you know, this project, they first applied 2 years ago. They've gone through extensive modification based on environmental issues, and they wanted to make sure that all parties were present, namely applicant, architect, their dock contractor, and the biologist. And because it was a duly noticed public hearing, staff's recommending that the commission open the public hearing, receive any public comment testimony, and then move to consider this item to the next Planning Commission meeting, which is January 5th. And if you have any questions, I'm available to answer them.
Very well. Questions for Richard?
Hey, Cindy, I think this is the same project. Remember, I stopped by, and then I had talked to a friend of mine, Mark Tognazini, over there in the dockside, and he said when they were looking at that one dock extension, they put some buoys out near his spot. I haven't been out there yet. Are you maybe, or just to put some buoys out there so people can get a visual? Because not only I think that would help, but also from a fluid standpoint, my understanding is it's a really tricky area with the currents there.
Okay, I think I know where you're going with the question. So the applicant did not, are you referring to visual simulations so that the public can see the extent of the dock construction?
Yeah,
okay.
Yeah. And then, when you see it, then you say, oh, this might be an issue there,
Right. We did not ask them to give us buoy simulations. They did submit 5 simulations, and those are, they are included in, they're actually on the plans. They are a page on the plan, so it's Exhibit D to your staff report. So you do see the dock construction. There is one simulation viewpoint that looks due west, and it sees that. And then, of course, they are limited by the extent of the release line for their the length of the slips.
Okay.
Are you suggesting that's something that you?
Well, I think that it would behoove us to have something like that out there, because what happened in a similar situation when they were going to extend the docks, they realized that when the big boat came in, they had when they had the buoys out there near the T-pier, they had to move that over a little bit. And this area maybe is not the same conditions, but I think that it would be beneficial for a practical aspect of it.
I can speak to that. So I think I know where you're going with this. So Mark Tognazini, I believe that the project you're referring to is the master redevelopment, and you can correct me if I'm wrong, of the GAFCO, the Harbor Hut, the former Verges Landing. When that came in, they were proposing new dock construction that was in close proximity to the, I think is it South T-pier? And there was, the harbor director at that time, this was many years ago, had expressed some concern about the maneuverability of slips, and especially because right outside GAFCO, they proposed replacing that existing floating dock and whether or not they would be able to maneuver those slips in. They do get much larger boats that are docked over there. For Rose's Landing, staff did not request that kind of simulation, that actual demonstration type of simulation, just because of its surrounding proximity. So page 1 of the staff report, you can see there's a aerial image of the site that points out the project location, and there's no other obstructions that would conflict with the ability to construct these docks. And in fact, these docks actually will be as short as 14 feet in slip length. So we will be seeing much smaller boats than what we are seeing over there by the South T Pier.
Thank you.
Other questions for staff? Any ex parte communications? I spoke with someone over there when I went to take a look at the area. I did not get the gentleman's name, and we didn't talk about this project at all. We just had a conversation. So. Okay, so this is a public hearing. I will open it up for public comment if there's anyone here to speak to this item. Seeing none, we'll close it and bring it back to commission. Do we have a motion to continue this item until our next meeting?
I'll make a motion to continue item C3 into the next meeting.
Second?
I'll second.
Yeah. Discussion? None? All those in favor say aye.
Aye.
Opposed? Very well. Okay, we're moving on to our item D. How do we feel? Do we want another break, or are we ready to wade into it? I don't see anybody running for the exit, so we'll go ahead. Item number D1 is case number CP0-460 and UP0-401, located at 485 Piney Way here in Morro Bay. And I'm going to just turn it over to staff.
Okay, thank you. And I believe AGP, I have a very short PowerPoint, but I believe AGP is going to put that on the screen for you. So this is an unfinished business item at the December 1st Planning Commission meeting. The Planning Commission voted 4-1 to deny the requested planning permits for a new wireless facility screened in a church rooftop chimney at 485 Piney Way. And, yeah, that'd be great. Okay, we're waiting for the PowerPoint slide to come up on the screen. Okay, well, I will go on. The reason stated for denial of this planning permit request, which was a coastal development permit and conditional use permit, were proximity of the proposed antenna to other wireless antennas and visual blight. And here is on the screen just a repeat of the image vicinity map that the commission saw at the last meeting. The red arrow points to the location of the church, located there at 485 Piney Way. So staff has, attached to the staff report, staff has included, of course, the letter from Chief Knuckles. This was additional information that was not known to the Planning Commission at the time of its deliberation at the last meeting. And so attached to your staff report is Resolution 4815, which is a resolution for denial. In addition, the guidance from the City Attorney's Office is the presentation that we heard earlier, identified two important factors, and that's the Planning Commission's consideration of, one, is there a gap in service, and two, is this minimally intrusive. Staff is requesting clarification regarding this resolution for denial in terms of presenting substantial evidence as findings for denial. And therefore, we are recommending that the Planning Commission review the information and, based on the information presented to the Planning Commission this evening, move for a reconsideration of this resolution. And with that, I'm available to answer any questions.
Thank you very much. Are there any questions for staff?
I would just like to state that I wasn't here for the original meeting, so I'll abstain.
So, and the vote, I think the vote was actually 3-1, Cindy. The vote was 3-1.
You are correct. I apologize. It was 3-1.
If there are no questions for staff, is there any ex parte communication to report? Seeing
No.
none? Pardon? No. Seeing none, this is a public hearing item. We will open this up for public comment, beginning with the applicant or applicant's representative.
Good evening, one more time. Tricia Knight with Verizon Wireless. I am here to answer any specific questions. I believe the vein of the conversations that we had during our last meeting on the 1st was that the overall aesthetics were not displeasing to you. We had actually worked with Mr. Hopper, one of the neighbors who had a view shed, and agreed to move the chimney back out of his view shed to address any of those aesthetics, as well as some potential screening around the equipment area. This site does fall under that area that Chief Knuckles referred to as having capacity issues, and I am here to answer any questions that you may have.
Okay. Well, as usual,
I'll be right here.
We'll do all the questions at the end. Are there other people who would like to speak to this issue?
Long night. Ann Travers, 595 Anchor Street. I wanted to start with a little history regarding cell towers in residential areas. And as far back as 2005, the city amended its land use ordinance and included a chapter on wireless communications equipment stating that no antenna would be located within 100 feet of a residence. The city council approved and adopted the amended ordinance. Why isn't the standard being used? That was 10 years ago. In 2010, again, a draft wireless ordinance was brought before the city council. I don't understand why that's not being used either. That also addressed the issue of, if I can find it, here it is, provide incentives for well-designed and appropriately located antennas, encourage the leasing of publicly owned properties where feasible, encourage the use of existing facilities and co-location of facilities by multiple service providers, encourage the placement of antennas on existing structure. I mean, you guys have been wondering why you don't have direction on this, and I think you have had direction on this. And I don't understand why these things aren't implemented when they've been adopted by the city council. I understand that the Coastal Commission is involved, but the Coastal Commission tells me that you could have moved ahead on this. It didn't have to wait. Okay. The other question was the issue of Assembly Bill 57, and is that going to force you to approve any wireless communications equipment application that comes your way? And no. This bill would provide that a co-location or siting application for a wireless communication facility is deemed approved if the city or county fails to approve or disapprove the application within the reasonable time period specified. And you've done that, so I think that shouldn't be holding you up. The other concern I have is, I got a city information sheet, and there are guidelines for illegal camping, for junk, for shrubbery, for signs, for water use, for parking your RV, for fences, and for garbage cans. Why aren't there guidelines for cell towers? So I kind of have been listening to you and saying maybe these are some of the guidelines you need to put in place. One, yes, create a map of all the cell antenna in the city limits and in surrounding areas. The county's got over 200, probably 300 plus cell sites now. Some of them are close to you. Okay, has the applicant proved that the cell tower will fill a significant gap in service? Are there alternative sites? Describe who will benefit from the cell services. If all of the antenna on the Presbyterian Church are facing west, does that mean that the neighbors east of Shasta, north of Anchor, and south of South Street will get any benefit from these antenna? What's the range of these antenna? Include an analysis of any new technology before approving permits. It seems we're always behind. We're still talking about satellite dishes. Can't you put something in an ordinance that talks about the future? Okay, ensure an equitable distribution of cell antennas with emphasis on placing cell antennas on public buildings, co-location, placement with utilities, and placement in commercial zones. No installation of a cell antenna within 100 feet of a residence. Determine that no one can put a cell antenna on their house. We haven't gotten that one fixed yet. On all public notices, include any cell addresses within 1/2 mile. Okay. You have guidelines already from the 2008 Special Use Permits, Chapter 17. Explicitly consider and determine that characteristics of a project use will not be incompatible with uses permitted in surrounding areas. Okay. And will cell antenna impact property values? Does the seller have to disclose proximity to a cell tower? In Ventura County, they do. You know, is that coming our way? And what's the city going to do when someone comes before you and says, you know, my house has been devalued because I live between 2 cell towers, which would be barbarous in my situation. The other thing I wanted to say is you're asking about, you know, the benefit for users, for those of us who have cell phones and tablets and wireless networks and yada, yada. You know, we've been having trouble with cell service for years now. We've had Charter out, we've had tech people come out, we have enhancers on our wireless networks, you know, we have enhancers on our streaming devices, and they keep saying to us we're in a highly congested area. And I keep saying to them, I live in a rural town. And they keep saying to me, you're in a highly congested area. Is this new antenna going to add, you know, a plus or a minus for us? I don't know that. The other thing is, Barbara and I walked the neighborhood over, you know, the last week, and we talked to several people, and they did have concerns about having a cell tower right across the street from them. You know, the folks in the apartments are literally going to be looking that thing in the face. You know, and that's just, that's not fair. You know, most of them are folks that have some issues. Most of them are renters. They didn't have a clue this was happening. They don't understand it. You know, we're not doing a good job of getting public information out there. You know, and just saying that it was, you know, I find it in the legal section of the paper. You know, why isn't it on our information sheets? So those are my issues. Thank you very much.
Thank you. Anyone else who would like to speak? Okay, seeing none, we'll bring it back to the commission for discussion.
Could I just make...
I find it really curious that now that Verizon has made some kind of deal with PG&E, that the city doesn't get in on this money. That's my comment.
Anyone else? Any other comments? Any? Not very well. Why don't you hit us again?
Verizon has made a deal with PG&E now to put their cell phone towers with them. Why isn't the city in on this? Why isn't the city making money? Why isn't the city doing something about this? They have a water tower up there. They have City Hall. The fire department is concerned, put it on top of the fire department.
Okay. Thank you. So bringing it back to the commission.
Could I, just before we continue, I want to make
Sure.
one, the attorney in me can't resist. When you first opened the item, you called it a public hearing, and for legal reasons, I just want to clarify for the record that this is under unfinished business and isn't in fact a public hearing, and just because legally there's different criteria in terms of noticing and what have you, so I wanted to make sure that was clear. And second, the only item before the commission right now is whether or not to make a motion for reconsideration. That's what at least staff's recommendation reconsideration is. It's not to revisit the entire idea. Procedurally, if a motion for reconsideration was approved, this would be set for your next Planning Commission hearing at your next meeting.
Understood. Thank you very much. And yeah, you're correct. This is not technically a public hearing item, but we like to hear from the public anyway.
Oh, absolutely. It's also legally required, but just, for other legal reasons, I just want to make sure the record is clear.
Very
Thanks.
good. Okay, so what are your thoughts on this? Discussion on this?
I'm comfortable with the decision we made 2 weeks ago, and even more so now because of the lack of data showing a significant gap.
I just think I think many people thought we did have something that kept things out of the residential neighborhoods, and I was kind of shocked that we didn't see more connectivity of the things coming through. I have to admit, I didn't look at the list and see, oh my gosh, there's 5 cell phone towers on our list. So I'm partially to blame for my own lack of curiosity, but just knowing the testimony we've had this week, the amount of email and things that have come through, I think we need to have a different kind of forum for airing this out. So I'm happy with the way it worked. If there's an appeal on it at a different level, perhaps we'll see more clarity on what happens.
First, I want to thank both the applicants and the RF engineer. Questions that Commissioner Lure, and that was very beneficial for me. But I also I'm comfortable with how we decided before, and I with the amount of community concern, we like I said, we have the law, but we have to we have to take into account the community's concerns and their perspective on these issues, and we just sound like a broken record, but we don't have the administrative infrastructure in place to address the integration of these kind of matters.
Well, I'm not going to make a motion because the outcome of that is fairly clear. I would like to express my concern because I do not believe the resolution as adopted is legally defensible. I do not believe that we have sufficient findings to support the conclusion. And I think we should be, as a commission, I feel that we should be more forthcoming because every piece of communication that I have seen on this matter has to do with RF frequency. And if we are choosing to make decisions on the basis of RF frequency in violation of federal law, then we should be upfront about it. And my impression is that that's what we're doing.
I don't agree. That's the legality and the parameters of the RF is. With regards to that, yes. But we not only have to see that, but we have to hear the community. And we, as a body, need to keep that pulse.
But that's what I asked her that question. I asked her, is community anxiety about cell towers a valid basis? And the answer was, not if it's based on RF.
Yeah, not if it's based on RF, but this is part of, I look at this as this is part of the backlash of not having a general plan and an LCP updated in a timely manner, because these emerging technologies have been coming through and taking projects in a piecemeal way isn't the most prudent way when you look at the planning of a city, and that's part of what we're dealing with here.
There's no question. There would be. I don't think anybody in town would argue that we need a new LCP and we need a new general plan, but the consequence, and that we have been derelict in not doing that. There's no question about it. But the consequences of that is, in order to deny an application, you need to say this is inconsistent with Section A, Section B, and Section C of our zoning ordinance and general plan. And I think with this resolution, we can't do that. We don't have the places to cite that say this is not permissible.
Chairman Tuff, I disagree with you a little bit.
I know.
I mean, and, one was the blight, I thought, with all the different cell towers and having a cell tower farm. But the testimony today and the presentation that we had, it's even crystallizing my thoughts on that. We do not have the data to support that there is a need. We have a letter, and in the case on the other one where I voted for it, we not only had the letter, but we had a discussion with our planning manager. And I think that swayed me for that one. On this one, we have an issue doesn't rise to the level that we have a significant gap in coverage to me. And I really do believe that's where I'm going with this.
I would just reiterate that I think there's a certain lack of respect for process, that we're a public hearing. And when someone comes up for a public hearing, there is no guarantee of what the outcome is. And I think that if it was something that was that cut and dry, we wouldn't have it in here. We'd have it in another kind of process. The fact that we have a hearing means that the community has an opportunity to come and express their values. And I think we have to take that very seriously. And I think it's wrong to assume that just because staff is unaware of some of these initiatives previously, or the fact that some members of the community are perfectly happy with having this technology. I personally do not have this technology, and it concerns me a bit when I hear things like the represented that all of us have this. We don't all have this, and so this is not a universal. And I think that we have to maintain the process as a public process. And I think that the nature of the holistic planning capacity of this town to understand this is very thin right now. We've seen a wave of things come up piecemeal, and it's only been in the last 2 weeks that we're starting to see this absolute inundation. Every 2 blocks now in downtown we have something. When we map this thing, it's going to be staggering what we have.
Okay, so
If I could just make one quick comment. With regards to the significant gap analysis, one of the problems, and we've talked repeatedly about fixing this problem, is we haven't asked the applicant for a significant gap analysis or a propagation map. So that wasn't part of the analysis that was done. On the other hand, like you mentioned, we do have a letter supporting the notion that there may be a gap in service. And I wasn't here at the last meeting, so I can't speak to what testimony was brought forth before the commission in terms of community members saying they had sufficient service, or perhaps community members saying they didn't have sufficient service. That's all the kind of evidence we would use as substantial evidence to support a finding one way or the other. So that's just something for your consideration.
Okay. Well, we don't really have to take action on this item, correct? It's brought up for staff is recommending that we move for reconsideration, but it doesn't appear that there's enthusiasm for that.
Yeah, you do need to adopt the resolution.
Oh, that's correct.
Because we put the findings as best we could based on the commentary from the Planning Commission in here, but you should be saying, yes, that's what we said, or no, staff, add X, Y, Z.
Yes, you're right.
Scott, we got some very meaty info today with the presentation from the attorney and from our applicants. That information needs to be processed, okay? So is there a way that we could just maybe postpone it, or because we need to probably these issues of significant gap and what is that? I mean, is it just capacity? Is it is it going to end up being we want a faster internet? I mean, these are the kind of things that as for me, I need time to mull it over, to process.
That's part of the reason why the recommendation. So we actually just internally had this conversation. Normally, these types of things, when we bring them back, would be on consent, and you just adopt them. But we thought it important to give you the presentation from the city attorney's office, and then you saw our recommendation was for reconsideration, so we could have some of those additional discussions about this. You certainly don't have to do that. You can adopt the resolution that's there, or you can say, no, it's insufficient. We want to add something to it based on what you've heard here this evening. That's fine as well. Staff, in our review of it, felt that the findings were fairly light and lacked some of the specificity, which is, if you read the staff report, kind of what I wrote into that, was that I had some concerns on those levels. We normally, when we review these types of issues and we say we have that notation that the area is blighted, but we didn't really speak to what the issue was with the design of the chimney, because these are stealth facilities. Normally, when we have discussions about things that we don't like about a project, design-wise, aesthetics-wise, we have that discussion. And I could tell anybody that's out there why the Planning Commission didn't like it, because you'll say it's mass or scale or bulk or one of these things, or it doesn't match the architecture of the building, or one of those things. I'll have that input from you. We didn't really have that last time, that discussion, and so it was, again, in my opinion, lacking some specificity, which is why the recommendation was for reconsideration. Anyway, I think I'll leave it at that.
Well, my sense tonight is the attorney suggested that the proof of coverage gap was on the applicant. Is that true?
It is true. That's when we asked for it. Unfortunately, before it got to hearing, before you guys, it was not asked for. So if that is something the commission would be interested in reviewing, then I think the next best move would be to continue, or to take staff's recommendation for reconsideration and reset this for a public hearing at our next meeting, so that the applicant can come back to establish for the commission, one way or the other, whether a significant gap in fact exists.
I think the other thing, though, is that this is cumulative. That, we talked about, we've got a bigger spire on the church down the street. We've got an unnecessary chimney element on the one across the street on this church. And so that now we're starting to accumulate what would normally be unnecessary pieces of infrastructure on residential area structures. This is dominantly a residential area that this one on Piney is going in. So, we're adding clutter to the visual corridors in our residential areas, which are prime real estate. And so when we talk about one, it's maybe not so much. When we start talking about 6 from one provider, and we start talking about 6 in one part of the city from one provider, I was concerned about 20. I'm thinking in the future we're going to have 40 of these things, because we've got another section of town that we're not even looking at in this discussion tonight. And that's a lot of stuff starting to accumulate. And the one on Quintana is not even disguised. And stealth is maybe disguised. It's not really stealth. You see these things. So I think there's a tangible aspect to the congestion, the accumulative congestion that we can anticipate from the technology in general starting to be so invasive in the residential neighborhoods.
Thank you for the additional commentary. That's actually helpful. Thank you.
Well, so then do we want to ask do we want to continue this and request that they bring in the coverage maps, or?
Let me ask the attorney, can we add, in consideration of the kinds of previous documentation that Ms. Travers brought up, can we add that as part of the preamble? This wasn't, in other words, our citizen bringing up the number of initiatives that had previously been considered by the Planning Commission and moved forward for implementation. Can we use those as items of consideration as well? They're part of the public record.
They are part of the public record. However, they don't have the force of law like it would have if the ordinance had been adopted and certified by your coastal commission. So at this point, they don't really add legal value. We could certainly add the language. I don't know that it would have any effect legally, but if the commission so desired, we certainly could.
Doesn't it meet the reasonableness standard? This isn't something we invented here tonight. This is something that's been debated for years here.
Unfortunately, when it comes to that topic, the legalities of the existing ordinance don't come down to reasonableness. It comes down to whether it was duly adopted and whether it has the force of law. And under the current circumstances, and from what staff's explained to me, it does not currently have the force of law.
But since it's part of a series of public hearings that was brought forward as concerns of the community.
I understand that, but concerns of the community as well don't have the force of law. From a legal standpoint, they're simply persuasive. If I were to argue this in front of a judge, I would be explaining to the judge what the concerns of the community were, as opposed to explaining what the legal standard was for the city of Morro Bay, which are very distinct and different when you're talking to a judge. And the concerns of the community are nothing, they're persuasive. They're not legally significant to the extent where I can say this is the legal line and this is what the city did. So again, we can add it to the resolution. I just don't know if it would be legally supportable in a court of law.
So a public hearing that produces a recommendation to a planning commission that moves that forward has no weight in law?
It's persuasive. It's not, if it's much like much of the state legislation that we have, and it goes through a number of subcommittees right at the state level, and it gets recommended, but then as groups become more aware of it, you see the legislation, develop as it goes through the process. And it's not until that legislation is fully adopted does it have the force of law. So those earlier drafts, we look at them for like legislative intent, for example. But it's, again, legislative intent is only persuasive. It's when it is adopted that it has the force of law.
So there's no precedent by things coming before a planning commission that obtains sequential, similar public discussion that doesn't have any weight.
No, certainly any city past practice, eventually, especially if it's a long-standing city past practice, does have significance before a court. I always tell the cities to always follow their processes and practices. That is something that, if the city has engaged in a certain practice over and repeatedly, it's something that we can again use that's, persuasive to a court to say, well, the city's doing exactly what it always has done. It's not discriminating. It's not changing its policies and treating this person differently than that person. It's a way to show the consistency.
So the actions of this board to consistently approve these cell towers prior to this move into the residential neighborhoods doesn't carry weight either?
It could. It absolutely could.
This has not been a commission that's been against the technology. It became concerned when repeatedly, after previous hearings, the towers started moving into the residential areas.
Yeah, the way this analysis would work is under the unreasonable discrimination analysis we talked about earlier. The city's prior decisions to allow a similarly situated antenna or wireless facility in a similar location, such as a residential neighborhood at a similar height, for example, will be considered. If the city ultimately then denies a similarly situated antenna, that's when the city could get in trouble under federal law. Now, what you're arguing is cumulative impact. And I think that's where, as well, Commissioner Sorensen is going for. The delightful effect of the gosh, it's late, isn't it? That impact has actually been looked at by some courts. Unfortunately, it's never been made extremely clear. And I think one of the reasons is because the significant gap analysis is carrier specific in the state of California. So, when you look at technologically, you may have a bunch of sites in an existing area. If those existing sites are Sprint, Metro PCS, and so forth, and they're not Verizon, Verizon saying they need to fill a significant gap, so it's probably going to supersede. Now, I don't know, but it's likely, given the case law I've read, would supersede the cumulative impacts that the commission would consider about the existing infrastructure, the existing wireless facilities, because the federal law says they're entitled to fill a significant gap.
But we don't know that.
No, because we haven't asked for it. So if the commission wanted to consider the significant gap analysis, I think staff's recommendation would be the way to go. Is you would make the motion to reconsider and set this at your next planning commission meeting. By then, you would request that the applicant submit propagation maps to establish a significant gap.
Wouldn't it be in the applicant's interest to appeal this and try to present that information?
It can go either way. I mean, I can't speak for what the applicant would do, but if the commission was so inclined to deny the proposed installation based on the failure to establish a significant gap, my recommendation to you would be, well, let's give them a chance to show it. Because to date, we haven't. And in absence of even asking them to do that, there's a letter that seems to support what they're alleging. So as your attorney, I would suggest that we give them the opportunity, since until today, I don't know that we've asked them for propagation maps.
We also don't know if the chief offered the fire station as a site, right?
I'm sorry?
We don't know what other sites were considered.
The alternative site analysis, true.
I mean, that's the thing that bothers me the most, is that we had something through these hearings previously that said we favored co-location, public sites that the city owned, commercial sites. That's gone past the boards, and we're starting to go into the neighborhoods. And that to me is very concerning, because we went through this process and established that. Now, what level that it gets approved at, I understand that's a legal matter, but this board is responsible for hearing the public and making recommendations, which we've been consistent in both supporting the towers and now having concern about the towers based on what the community is saying as input. So I'm very concerned that there's a planning aspect of community values here. It's not being given any kind of, credit, when we have accommodated these towers in numerous locations.
So I guess the question is, if they demonstrate that there is a significant gap, would that change the commission's decision? I mean, it's kind of not fair to ask them to go through that step if we're not going to consider it, with an open mind.
Well, I think that we would always consider new information and make a judgment based on it. But again, I think we're getting away from the cumulative aspect of all of these cell towers in a very small area. And, and that's really was the basis of our denial and at the last meeting. And I haven't heard too much more about that other than, your comments. But certainly, any new data, you always will, reconsider things.
Not hearing anything from that end of the table. In other words, is it a hoop that we should reasonably ask them to jump through?
Earlier we talked, there was a suggestion where you have a master permit kind of thing, right? I really dislike any kind of, I think when you go to, I know that lawyers make money in court, but it's like you're the only ones, and it's a cost to all the communities. So we try to avoid anything in that genre. And what's the likelihood of, we have all this history, like one of the speakers said, what's the likelihood that we could say, one of the things that I'm uncomfortable of is saying, okay, there's going to be ordinance coming down the pipe and try to sneak in. And I'm not saying that this is what's going on, but there's an appearance of trying to get a bunch of stuff through under the grandfather rule. You were there before that ordinance. But when you look at it from a public health issue, okay, public concern, okay, regardless of their perspective, I think that there is a solution here where we could come together without courts, but it would take getting the right parameters in there, an ordinance where we can say, yeah, let's get this in place, and then it makes it a lot easier. And then the public knows too, and say, hey, we got this, we got these kind of things in place.
It's a great idea, but we have an application before us.
Yeah, and an ordinance, related to wireless facilities on private property is 8 to 10 months away if we started right now, because it requires certification by the Coastal Commission. Would be faster for the portion, and we just was discussing that with the city attorney, would be faster for those areas in the right-of-way, because that wouldn't have to be in the zoning code. So, and that's something probably I'm going to look at pursuing, because I've requested that she provide examples of some of the other ordinances that address that. So half of it is something we can probably look at right away. The other half is something that's going to be more prolonged.
Let me just ask the question procedurally. If we do not reconsider, the applicant can appeal, correct? Would there be an option where the applicant sues before appeal?
They can't.
No.
Well, I guess they can always take us to court, but they need to exhaust their administrative remedies, and that would be to appeal it to City Council.
And this will be appealed if we go forward with it.
If you adopt the resolution, yeah, I'm fairly certain the applicant will appeal it to City Council.
No, I mean,
and they've also heard the fact that you're interested in the gap analysis. It would be, I think, somewhat foolish on their part not to provide that to the council when they went there, because it was a significant discussion that you've had here this evening.
My sense from the tenor of the email I received, which we all received today, my sense is that it will be appealed either way. If we would go forward on this, if we would rescind this and approve it, it'll be appealed. And if we deny it, it'll be appealed.
That may be the case.
So I think it's going to be appealed one way or the other.
Certainly a possibility.
Certainly.
So it may be that the most direct course of action would be simply to adopt the resolution, let it go wherever it's going to go, and kind of the applicants kind of know what this body has felt we needed to see, and perhaps they'll carry that forward to the City Council level.
Move to approve resolution number PC 48-15, UPC-402 including in it the additional comments under coastal development permit findings that Commissioner Lucas spoke to during this conversation. And that's it.
I'd also like to propose that the whereas acknowledge previous discussion of cell phone tower resolutions put forward from this panel in consideration of the past record by the community in hearings.
Can you repeat that finding, Commissioner Sorensen?
When we talked about the creation of visual blight, there was additional comments from Commissioner Lucas that clarified that, and I think that Scott has those comments to include into the resolution.
It has to do with the aggregate visual clutter from potentially 20 to 30 utility constructions within our residential neighborhoods, which affect our view potentials, which have tended to be extremely important aspects to the community in other projects brought forward. And I'll second.
Okay, we have a motion and a second. Can we have a roll call, please?
Commissioner Lucas.
Aye.
Commissioner Sadowski.
Aye. Aye.
Commissioner Sorensen.
Aye.
Chairperson Teft.
No.
Okay. Motion passes 3-1 to adopt Resolution PC 4815 with the revised finding and the added whereas section. Thank you. Permit denied.
Okay. Moving on, we have Planning Commissioner comments. Are there any further comments, announcements, thoughts? Seeing none, we will move on to Community Development Manager comments.
I have only one item, just kind of an FYI. We're conducting our consultant interview for the General Plan and LCP update tomorrow from 3 to 5 at the Community Center in the multipurpose room. That's all I have.
Very good. Planning Commissioner comments? New business was item D. Or, no, new business was item B. I think we have a planning commissioner comment.
Yeah, I'm sorry. I was in transit there. I've got a concern, and I'd like to bring it up to the Planning Commission about the mobile homes that are being installed in Morro Bay. And I would like us to get a clarification on what is allowed and what's not allowed. As far as I tried to pull up the exact wording today, but the municipal code site was down. I couldn't get it up. But there, essentially, it says that mobile homes are allowed, and correct me if I'm wrong, Scott, on the wording, that mobile homes are allowed to be installed by state law. We can't deny them, but they're required to have a permanent foundation and required to have the appropriate parking. Covered parking. Okay, well, there's one being installed now on Greenwood, and I think there's another one being proposed that is not, it has, the foundation system that it has is basically A-frame jacks that are sitting on top of a non-structural fill, a non-engineered fill. So essentially they're sitting on blocks. And I think we need to get back to where what was required before was that these mobile homes were installed on a continuous foundation that was set below the wet-dry cycle and was tied in so they would resist uplift. The way they are now and what is allowed to be set on a non-engineered fill, set on top, so that they will move with the wet-dry cycle of the expansive soils that we have. So there was no soils report required. There was no geological report required. All of these things are required on a traditional new house construction, and I think that these mobile homes should be required to meet the same standards that we require for other new home construction that's being in place in the city. Because what it does is it will devalue the neighborhood, and then these mobile homes on substandard foundations can be placed anywhere in the city. They could be put next to anybody's house. So I think this is worth the Planning Commission's look at clarifying and getting a clarification of the wording so that the staff has better tools to work with.
Can you speak to?
So yes, Commissioner Luer and I have spoken about this a couple of different occasions. So the city, we have an ordinance that allows for manufactured homes to be installed in the city. So Commissioner Luer is correct in that, and the state requires us to allow those. So that's permissiveness is sort of out of our hands. Moving forward, all it says is that it has to be on a permanent foundation, subject to my review. In the instance of the one on Greenwood that he was referring to, that Commissioner Luer was referring to, when we took a look at that, because that's not a much direction in the ordinance, I get to make the decision. So I didn't just flip a coin and decide what was going to happen. I actually went to the website for Housing and Community Development, HCD, and took a look at what they have on their website for permanent foundations. There are two types. There's one that's a poured-in-place stem wall type foundation, and there's another that basically utilizes the jacks. Those are the two types of permanent foundations that you can use and still obtain FHA financing. And so that was the parameter I used in determining what type of permanent foundation was acceptable and allowing the foundation that was associated with the one on Greenwood to go in. Those are the parameters that I used, and that was the scenario that Commissioner Luer is talking about. As to the question as to whether there was a soils report or not, I don't actually know. I'd have to go look. I didn't review it. Our building inspector did, and I'd have to ask him whether we required one in that for the property or not. So.
And I don't know if there was a soils report, but I know there wasn't any engineered fill brought in.
Yeah, you're correct. That did not happen.
So this is an issue, just on the mechanics, this is an issue that could probably be addressed with a resolution, right? Clarifying the requirements.
I think so, and it'd probably be worth bringing to you those items that I just discussed with you. I could bring the two foundation types, the examples from HCD, as well as the clause that talks about FHA financing, as well as the ordinance itself that allows the manufactured home, so you can see it, and then you can have a discussion. So it could be something we agendize for future conversation.
Yeah, and I'm sorry, Scott, I don't mean to be creating more work for the staff, but I think this is an important item, and it's been brought to my attention by several members of the community. So,
is there sort of a general agreement to look at that?
I think it's an interesting point, because the biggest thing I'm always concerned about is how do we protect the investment of people who come into a neighborhood. And if you think you come into a neighborhood and some kind of substandard situation, the Jackson things to me this is getting commentary, but yeah, I think we should look at this. There's something about, you don't want to have a situation with seismic and water, and you don't want to have a situation where your neighbors' utilities get disengaged, gas line breaks, sewer break, because they don't have the same expectations of hooking into the utility infrastructure that a typical house would have. So it's not that the house itself has a stigma, it's the nature of connections relative to things like insurance. And I think that's building code, though, more than zoning. But, if we need to bring it up into this kind of level as opposed to that, I would think there would be seismic regulations and things about latching that puppy down. But I may be wrong.
Manufactured homes are treated like assemblages. They come with a book of all the requirements that go with them.
But there's a difference between a manufactured home and a mobile home to a degree. Are you talking about is it just a modular thing manufactured?
Well, there's prefabs and there's, and one of the things I would encourage is prefab homes. I mean, but the whole thing with prefabs are that they're put on, competent foundations. And this is, that's the only issue I have with these, that they meet the parking requirements. They meet the same requirements that a normal home would be. Otherwise,
we shouldn't get too much into discussing this, because it's not. The question is just, do we want to agendize this for a future meeting? Okay. And I think we have a consensus.
Okay, that's good. It'll probably come back, and we have a couple of full agendas coming up, so it'll probably be maybe month and a half out. Okay.
Yeah.
All right. Okay. Thanks.
So any other comments from anybody? Okay. If not, then we will adjourn to our next meeting here at the Veterans Memorial Building on January 5th, 2016. Merry Christmas and Happy New Year to everyone. Oh.
My goodness, that's a beautiful guy. Oh, sure.